Are we allowed to upgrade a system? There's already an order.
Why?
This matter relates to discharge without inquiry, but my interim prayer is for subsistence allowance.
Huh?
Subsistence allowance during my suspension period. That has not been paid. There is a dusty service now. I have filed an affidavit to that. Right.
Lordship, I beg to mention item number 8. 18, Lordship. In this case, respondent number 2 file affidavit on opposition. One week time may be allowed to file our reply letter.
The request of the learned counsel for the petitioner matter stand adjourned for 4 weeks.
May it please your Lordship. Lordship, with regard to item number 52, Lordship, that tender matter, Lordship. Lordship, we have filed an affidavit. Lordship.
May I please your Lordship? Your Lordship, I beg to mention item number 24 and 44. Your Lordship, in item number 24, I am on behalf of the petitioners, Mr. J. Roy, who is currently under your Lordship, and we have already filed our affidavit in reply on 25th of May, your Lordship. Your Lordship, we need just some more time to prepare our matters. Your Lordship, and in item number 44, my senior, Mr. J. Roy, appears for the respondents, your Lordship. And in that matter, we need some more time to file our affidavit, your Lordship.
Why it has come up for orders?
This is for the affidavit, your Lordship.
We have not filed it.
No, your Lordship, we need some more time to file the affidavit.
Item number 24, I will adjourn it for 4 weeks, but not 44.
So we have taken consent from the other side, your Lordship.
You take your consent, that is your lookup. I am not concerned. As regards 44, no agenda. We'll look into it. Item number 24, 4 weeks.
Okay.
Item number 25 has become only 5 has become
Huh?
infractious matter. Item 5 matter, daily list.
Top of the list, Lordship.
Yes, last item has become infractious matter in the meantime matter.
Mr. S.R. Mukhtar, the learned counsel appearing on
SK Mukhtar.
Huh?
SK Mukhtar.
S.K. Mukhtar, the learned counsel appearing on behalf of the petitioner. Mr. You appear?
I
SK
appeal,
Mukhtar.
Lordship.
Mr. K. Gogoi appears on behalf of the respondent.
All the respondents, Lordship.
The learned counsel for the petitioner submits that the petition has become infractuous. Accordingly, the petition stands closed as it has become infractuous. Interim order,
It's all only subject to outcome, Lordship. Similar in item number 21, it's a matter also in practice. Because payment has been done.
which one?
21 item number.
Mr.
NC that.
S.C. Das.
NC.
N.C. Das, the learned counsel appearing on behalf of the petitioner. Mr. N. Khatonier appears on behalf of the respondent elementary education department. Mr. R. Balpudari appears for the finance department. The learned counsel petition for the petitioner submits that the petition has become infractious. Accordingly, the petition stands closed as it has become infractious.
Much.
Item number 1.
Similar matter of disposal of justice matter. Similar matter was disposed of. There were a series of matters.
My lord, similar, there we had filed an affidavit, but here, my lord, we are yet to file, but my lord, I will go with that, but there is a small thing, just I want to place it before your lordship, my lord.
Now, what is this case about?
This is, my lord,
Non-payment
of supply materials, my lord. Now, here is the case, my lord. there the writ petitioner is before your lordship seeking a direction from this court for this non-payment of the bills. Here, my lord, the respondent number 4, the marketing corporation has given them a supply order, my lord. The supply order is in page number 24. And in page number 24, my lord, that is the supply order given to the writ petitioner,
It is on the basis of which the petitioner is claiming.
claiming, my lord. And my lord, there is another thing, my lord. This respondent number 1 and 2 has given the job to respondent number 4. And in that, like my lord, a sublet, they have again given this job to the writ petitioner. Now, my lord, there is an agreement in page number 29 between the writ petitioner and the my lord respondent number 4. I will just take my lord, page number 29 is the agreement, deed of agreement signed between the writ petitioner and respondent number 4.
Who is
My-
applying for respondent number 4?
Respondent number 4, my lord, yesterday evening I got an my lord instruction, telephone instruction that I should represent my lord.
Now,
Now page number 31, my lord. My lord, I'm coming there.
yeah.
Page number 31, last paragraph. The first party, my lord. First party here is the respondent number 4. The first party shall release the payment to the second party, that is the writ petitioner, only on the receipt of payment of the such and such from handloom and textile, that is 1 and 2, my lord.
Yes.
The corporation will not be responsible for any delay, failure, lapse on the part of directorate. So, my lord, here the thing is that it is little tricky, my lord.
Understood. The trickiness is here. Are you appearing for 1, 2, and 3?
My lord,
Are you appearing for 1, 2, and 3?
actually, I am appearing for 1 and 2, my lord. That
Then
is-
if you are appearing for 1 and 2, wouldn't that be a conflict? If you are raising that issue,
exactly, my lord.
then you know
No,
that then also you're
My lord,
raising.
what they really, all these 3 they have agreed upon, they will pay, my lord. But let my lord dispose of this matter only with the rider that once this 1 and 2 releases the money, they will pay. They are not disputing, my lord, that they have.
But 1 and 2 is before this court, appeared by the same counsel. So the direction has to be given to you also to pay to the respondent number 4, who shall then pay to him. Isn't it? If you were not appearing for respondent number 4, it would have been a
My lord,
different
actually,
thing.
whatever this matter didn't come up, and they actually I called up them yesterday night. After seeing this, I called up this managing director. This is the scenario, and they said we are not aware. Means they haven't received this 1 and 2 is there, my lord. So I said, see, this is the thing, and on the last occasion, even some.
So you'll verify and make the payment. And for that, the respondent number 1 and 2 will take appropriate steps in that regard for payment.
and-
If he is
and-
entitled to.
and they will verify, my lord. They will verify.
That is what I'm saying. I am
My-
not asking them to make the payment.
My lord,
I'm
my
not.
lord, my lord. That is what, my lord. We even don't want this to be, my lord, keep in this way. Let it go, my lord. Only the thing is that we have to verify, my lord. All the things.
Absolutely, you verify.
And my lord, 1 and 2 will provide, and 3 will at the release the thing. 4, my lord. That is the thing, my lord. I don't want to keep this holding ever, my lord.
1 and 3.
1 and 2, my lord.
1 and 2 is he.
Yes, my lord. I am, my lord.
Finance is made via party. Why you are antagonizing the finance, madam?
Because, my lord, ultimately finance will give the money because we also don't have money.
Oh, but I think when a contract is given by
My lord,
you
that was in,
to the respondent number 4, which is also you,
my lord, that was
obviously you must have a
in,
budget for
my
that.
lord, that was in 2015-16.
So,
So, my lord,
so did you give the
th-
contract
that
to
has
somebody?
My lord, whatever thing we had, that is left, my lord.
Lordship, 28% payment already made, Lordship. 28% payment already made, Lordship.
Not
And
only
remaining-
this case, there were some other cases also. But here the factual matrix background is like that, my lord. Just before the assembly elections
One day.
in the year 2016, my lord, just prior to that, my lord,
The wool, the cotton,
Yes, my lord, yes, that one.
normally in common parlance, what we say, my lord,
Khutakumbho,
Khutakumbho Rajniti. So it was something like that. So,
That is the
my
one.
lord, without adhering to the norms, basic norms, my lord, with regard to distribution of state largesse, the state, my lord, flouted all norms, my lord, and they just issued the work orders, my lord. Now, in doing so, my lord, some of the, my lord, suppliers, they, my lord, made supplies. Some suppliers defaulted. Ultimately, a batch of writ petitions, my lord, was finally decided by this honorable court, my lord. During the hearing, it came into light, my lord, that this handloom textile departments and finance department, they both, my lord, took an exercise and find out, my lord, there were gross irregularities. And a high power committee was constituted. Finally, my lord, some parameters were laid down and that money was released, my lord.
what is the parameter?
My lord, parameter, that judgment, my lord, perhaps we may brought it to my
No,
lord's notice. Yes, yes, it is there, my lord. It is there in the writ petition itself.
Where? Oh, power of report of the high power committee.
Yes, yes. My lord, if my lord may be pleased to come to page 64. Page 64. Page 64. It starts from page 64
Following
onward.
company are from group A, so and so, so and so, so and so, and NOC obtained under the. Page 60.
It starts from page 64, but my lord may kindly come to page 81. Page 81.
Yes.
Page 81, paragraph 69 onwards. AGMC, my lord, that is the Assam Government Marketing Corporation. Here, my lord, it is the respondent number 4. AGMC on its part adopted a strange procedure. What it did is in turn issued supply order to one party, so and so. So these were the findings. Then, my lord, Lordship may kindly come to the next page, my lord, paragraph 71. And just trying to, my lord, draw my
No,
lord.
it is on the basis of this, the power committee was formed.
Absolutely.
Then what happened to the high power committee?
Then high power committee, my lord, page 86, my lord, page 86 of the writ petition. That is the, my lord, operative portion.
That
high
I've
power-
seen it. The
yes.
committee shall examine the payment of dues to the petitioner for
Yes,
supply
not-
of so and so.
Yes.
And the
Page-
quality and
page-
so and so and the contractor. Further, committee shall examine violation of the tender norms and fix responsible aware of the department. So
Yes.
this is a direction given to the high power committee to look into those aspects.
Yeah,
of the
and the
matter.
report, my lord, will find from page 88 onwards. Page 88.
What is the finality in the report?
Final, my lord, high power committee came to various findings, and finally, my lord, page 97. Page 97. The comprehensive and chronological report submitted by the Director of Handloom and Textiles, along with the enclosures there to have been perused and also the following points emerged for consideration. For Group A, supply order was given to so and so. Then, my lord, Group A portion of supply order was given to so and so. Then Group C. Then, my lord, at serial number 6, my lord will kindly see 5 and 6 for Group E supply order was given to so and so who were L4 instead of giving supply order to L1. So these were the irregularities and infirmities.
But the report says that don't attach any criminality upon the director of handloom after what he has done.
That is the finding, but if my lord precisely come to my lord page 98, that is the my lord last paragraph. Page 98, I am reading it, my lord, the last paragraph. In terms of the honorable court's order, this committee is also required to examine as to whether any criminality is involved in tendering and supply so and so. In view of what has been discussed here, the committee is of the view that with regard to supply of cotton here no criminality is involved. In respect of polar blankets, the disputed facts that showing so prima facie.
No, you do one thing.
Yeah.
You return the handlooms and wool and whatever you have taken to them. If you have any problem.
No, but here is a case, madam, if they have
No,
supplied.
if you don't, if you have taken it, you have to pay it.
Absolutely.
There's no worry. So either you return, you have given an option to return it to them, or you pay.
No, my lord, we are not disputing that we haven't taken it.
No, I'm just doing
No, all these HIPAA committee and all these things which are being said. Yes, there were a lot of irregularities, but whatever maybe you have taken, either you collect it from those airing officers, whatever maybe you want to do it. But there were certain illegalities, those illegalities were never challenged nor set aside by any authority. So under such circumstances, you are liable to pay. Better ends there.
Lordship will only give one rider, my lord, kindly that department will verify.
Oh, that too obvious.
Okay. My lord, the quantum of supply and nature of supply. If it has come to the hands of
And-
the
and-
government, I am the end user. my
Mr.
lord.
Borpuzai,
Yes.
let me
My
dictate the order. You
My-
will,
my-
if you
my-
have anything, you let me know.
My lord.
Because my, if.
Yes, madam, what is your name?
M Das,
M.
M Das.
M. Das, the learned counsel for the petitioner. Mr. Ardhor appears for the respondent number 1, 3, and 4. Mr. R. Borpuzari appears for the respondent number 2. The case of the petitioner herein that pursuant to a e-tender notice dated 30/10/2015 for supply of polar blankets bracket 100% polyester from registered manufacturers or his authorized dealers for procurement under the Chief Minister's Special Program during the year 2015-16 for supply of the aforesaid materials in 6 groups. The respondent number 3 issued a work order to the respondent number 4. Wide order bearing number DHTP.73/2015/196-99 dated 18/1/2016 for supply of 44,26,565 pieces of polar blanket for distribution to the beneficiaries under the Chief Minister's Special Program for the year 2015-16 in respect to the group A, C, and F. The amount of quantity to be supplied in each of the groups were very well were also set out in the said order, as well as the rate at which the said supply was to be made. On the basis of the said work order, on 18/1/2016, an agreement was entered into between the respondent numbers, between the respondent number 1 and the respondent number 4. Subsequent thereto, on the very date, that is on 18/1/2016, the respondent number 4 issued a work order dated 20 word dated no, on the basis of the work order agreement dated 18/1/2016, the respondent number 4 issued a work order to the petitioner on 21/1/2016 as handling agent for supply of 85,031 pieces of polar blanket under Group A for distribution to the beneficiaries under the Chief Minister's Special Program for the year 2015-16. On the basis of the said work order, an agreement was entered into Full stop. At this stage, if this court peruses the agreement which have been enclosed as annexure 3 to the requisition, it transpires that amongst various clauses, one of such clause is that the respondent number 4 shall release the payment to the petitioner only upon receipt of the payment from the indenting Directorate of Handloom and Textile Assam after deduction of 2% service commission and other taxable amounts. It was further mentioned in the said agreement that the respondent number 4 would not be responsible for any delay caused due to the failure of the lapse on the part of the respondent number 3, that is the Directorate of Handloom and Textile Assam, in releasing the fund for supply of the materials. It further appears that the petitioner claims that the petitioner had supplied the said materials in terms with the agreement entered into on 21/1/2016 and had raised an invoice bearing invoice number dated 29/2/2016 amounting to rupees 28,31,000 2,83,15,068. In the meantime, while the said claim of the petitioner was subsisting, there were various other writ petitions filed before this court claiming amounts on the basis of supplies made pursuant to the Chief Minister's Special Program for the year 2015-16. The coordinate bench of this court, by the judgment dated 28/6/2019, passed in WPC number 2610/2017 and analogous matters, was of the opinion that a high power committee is required to be constituted to look into the various aspects pointed out in the said judgment and thereafter to take appropriate decision. In paragraph number 83 of the said judgment, the coordinate bench of this court further expressed its opinion as to what the high power committee was required to do. Paragraph number 83 of the said judgment is quoted here in below, page 87 of Pagode. It further appears that pursuant to the judgment dated 28/6/2019, passed in WPC number 2610/2017. The High Power Committee submitted a report on 30/1/2020. From perusal of the said report, it transpires that the High Power Committee did not make any recommendation for cancellation of the orders or not to pay to the suppliers who supplied the amount. Be it as it may, that pursuant to the High Power Committee's report, on 30/4/2020, an amount of rupees 79,28,219 was paid to the petitioner. However, an amount of rupees 2 crores 38 lakhs 6 2 crore 2 crores 3 lakhs 86,849 remain pending.
No, my lord,
As claimed in the writ petition, for which the instant writ petition has been filed seeking a direction for payment of the said amount along with interest at the rate of 24% per annum. It appears from the records that on 29/2021, this court issued notice and further observed that pendency of the writ petition shall not be a bar for the respondents herein to release the amount as per his entitlement, following the due procedure and in accordance with law, if there is no impediment in releasing the same to the petitioner. However, the said matter thereupon has been listed today before this court. The instant matter thereafter has been listed today before this court. Mr. Ardhor, appearing on behalf of the respondent number 1, 3, and 4, submits that as per the records, no, he's on the first page, Mr. Counsel. Why are you on the second page? His case is not for second page. His case is for first page. This amount, 2 crores 83 lakhs, 79 lakhs you have paid. You get it? The first page. You have this document?
Yes, madam.
See, the first page.
It's not wrong. 79.
Ah,
79, yes, madam.
yes.
Same and almost,
Yeah.
my lord, obliged, my lord.
Should I think I should not bring this.
My lord.
The moment I say this, wouldn't that be an admission on your part that he's entitled to?
My lord, my lord,
Then how can I say about verification?
my lord, my lord.
I've heard the learned counsels for the parties and perused the materials on record. The learned counsel appearing on behalf of the respondent number 1, 3, and 4 submitted that the payment that as per the clause of the agreement dated 21, agreement dated 21/1/2016. The respondent number 4 would only be entitled, would only make payment upon receipt of the amount from the respondent number 1 and 3. And as such, till the amount is received by the respondent number 4 from the respondent number 1 and 3, the petitioner does not have an enforceable right seeking a direction from this court for payment of the said amount. This court put a specific query upon the learned counsel appearing for the respondent number 1, 3, and 4. As to whether the petitioner had supplied the said amount, said materials, and as to whether the order by which the petitioner, and as to whether the work order as well as the agreement on the basis of which the petitioner supplied have at any point of time terminated or cancelled by the authorities. The learned counsel for the respondent number 1, 3, and 4 therefore submitted that the fact that the petitioner had supplied some materials in pursuance to the work order and the deed of agreement dated 21/1/2016 is not in doubt. But the fact how much the petitioner had supplied is subject to verification. Good idea. The learned counsel further submitted that this aspect, the learned counsel further submitted that the amount so payable to the petitioner upon verification would require some time to be obtained, taking into account that the budget on the basis of which the said work orders were issued by the respondent number 1 and 3 have already lapsed. He therefore submitted that for that purpose, there certain approvals would also be required from the finance department in that regard. Upon hearing the learned counsels for the parties, and taking into account that the agreement between the respondent number 4 and the petitioner, and on the basis of which the petitioner had already supplied this court is of the opinion that the petitioner therefore would be entitled to the amount in respect to the supplies so made in pursuance to the agreement dated 21/1/2016. No doubt, there is a clause in the agreement to the effect that the petitioner would be entitled to the amount only upon receipt of the money from the respondent number 4 from the respondent number 1 and 3. But too long a delay in disbursing the said amount by taking recourse to the said clause, in the opinion of this court, would render the said clause arbitrary and unreasonable. This court further is of the opinion that that the extent to which the petitioner has supplied is a subject matter, is always subject to verification. Would require certain verifications, which on the basis of the materials before this court is not in a position to do so. Considering the above, the instant writ petition therefore stands disposed of. Directing the respondent numbers 1, 3, and 4 to make necessary verification as regards the supply so made by the petitioner. And thereupon, if it is found that the petitioner is entitled to the said amount claimed in the writ petition, or such other amount as arises, as comes into existence, as is computed on the basis of verification, the said amount be paid to the petitioner. In that regard, the respondent numbers 1 and 2 may submit appropriate proposals. The respondent number 1 and 3 may submit appropriate proposals before the respondent number 2 for sanctioning the said amount if the fund budget had already lapsed. And the respondent number 2 shall also take appropriate steps so that the petitioner gets his entitlement. It's entitled. The said exercise be done within 6 months from the date a certified copy of this order is served upon the director, upon the respondent number 3 and 4, respectively. 6 months to Kuluna. Within 6 months, Kuluna. We completed within 6 months from the date. Certified copies of this order, judgment is served upon the respondent number 3 and 4 respectively. With the above observations and directions, the petition stands disposed.
Deep development.
This matter I would have disposed of on the first day as a motion.
Item number 2.
My lord, yesterday's that Mekhla Sador.
You got something?
I got this from the
Fantastic.
department. my lord.
I was
have
also
black-
looking for some.
And my lord, that mine is
Okay.
original. I'm just living in mine.
Because I need something.
My lord,
Otherwise, I would have dictated the judgment yesterday, but I thought about it.
my lord, this is cyber science from the department only. This is
Because that is very important there. Because you need to, because this will have a far-reaching consequence
very,
in all over India.
yes, my lord. Art, silk and everything is, it's there, man.
Thank
I have flagged.
Yes, Mr. Counsel,
May I please, Your Lordship?
what are you asking for?
In this case, Your Lordship, I asking for direction to the respondent.
Eh?
Asking for direction to the respondent authority, Your Lordship. As because, Your Lordship, in this case, Your Lordship,
Asking for what?
a direction, a simple direction.
For why?
Because payment for ex gratia related.
Ex gratia,
Yes, Lord.
2 lakhs,
Yes, Lord.
24/4/2077.
It is 14.
14.
It is 14.
He comes under the 14 act.
Yes.
Lots.
14/11/2014. 15/11/2014.
15.
This is also 2 lakhs.
Plus.
Earlier it was 1 lakh.
All.
কালি এটা order দিছো এইটো অকমান বেলেগ হ'ব। কিন্তু I have some orders passed in these types, no?
Lord.
You have it?
Yes.
There are many orders passed on this 15/11/2014.
Still, I have not, but I will give
Huh?
later.
Passing these orders is. Hello. Okay. Heard Mr.
Yes, sir.
S.I. Akkad, the learned counsel for the petitioner. Mr. N. Goswami appears on behalf of the respondent number 2 to 4, and Mr. S. Doctor appears for the respondent number 1. The instant with petition, now taking into account the question involved in the facts as well as the question involved, the instant with petition is taken up for disposal at the motion stage itself. The facts of the instant case is that the petitioner is the father of one Dipjyoti Deori, since deceased, who unfortunately expired in a road accident which took place on 12/5/2021 at about 5:15 p.m. Pursuant to the accident, there was a postmortem conducted by the doctors of the Guwahati Medical College, in which the cause of death have been wherein the cause of death has been mentioned as inverted comma, death was due to coma as a result of head injury as described. All the injuries were antemortem caused by blunt force impact, inverted comma closed. It has also been mentioned that there is that pursuant to the said accident, Honapur PS case number 323/2021 was registered under section 279/304A of the Indian Penal Code. The petitioner thereupon on 9/8/2021 submitted a representation to the respondent number 2, that is the Deputy Commissioner Kamrup Metro, making a request to grant the amount of rupees 2 lakhs as ex gratia relief, being the next of the kin bracket NOK of the deceased as per the government notification dated 15/11/2014. However, in spite of the said representation, as the respondent authorities set over the said representation, they did not take steps for redressal of the grievance of the petitioner, redressal of the did not take any steps for granting the entitlement to the petitioner. The petitioner therefore has approached this court under Article 2 to 6 of the Constitution. Next. It appears from the record that the notification dated 15/11/2014 has been enclosed as Annexure 5 to the petition. In clause 3 of the in serial number 3 of the said notification, it has been mentioned that next of the kin bracket NOK of person killed due to accident in public places or in public carriers other than those killed by extremists, oblique terrorists, oblique miscreants, and due to firing of security forces bracket close, would be entitled to an ex gratia compensation of rupees 2 lakhs. It further appears from the records that an additional affidavit was filed by the petitioner bringing on record the next of the kin certificate issued by the Office of the Deputy Commissioner Kamrup dated 24/2/2022, wherein also it is seen that the petitioner has been shown as the father of late Dibjyoti Deuri. Considering the above, this court therefore is of the opinion, there is therefore, considering the above, this court therefore directs it is further relevant to take note of that the respondents have till date not filed their affidavit. And as the instant writ petition has been taken at the stage of motion, this court therefore is of the opinion that the claim of the petitioner requires to be verified by the authorities concerned. Considering the above, this court therefore disposes of the instant writ petition, directing the respondent number 1, you. All along I have been directing 1.
Yesterday
Yesterday is 1 lakh.
Yes.
This is 2 lakhs. Now it has become 5 lakhs.
no 2 lakhs.
2 lakhs.
So it will be 2 lakhs by dint of the 2014 notification, and the verification will be done by the Office of the Deputy Commissioner, because he has the required machinery, my lord, to conduct verification.
Directing the respondent number 2 to make necessary verification as regards the entitlement of the petitioner in terms with the notification dated 15/11/2014. To stop. This court further directs that upon verification, if it is found that the petitioner comes with, is a next of the kin. And bracket NOK of late Dipjyoti Deori. Dipjyoti Deori, na?
Yes.
Of late Dipjyoti Deori, who expired in the accident. The respondents shall make payment of the amount of rupees 2 lakhs to the petitioner, as it is the mandate of the notification dated 15/11/2014. Pustak. The said exercise be completed within a period of 4 months from the date a certified copy of the instant order along with the particulars necessary is submitted before the respondent number 2.
Item number 4, I have 3.
Three also same.
Same order.
Same.
Who died?
Person is deferred, husband died. Petitioner husband. That's
Don't tell me Dipjyoti Deori is her.
not.
Huh? Okay, order type kori diba, naam kita bodlai diba, huh? Itu okon sai lobo.
DPO.
Number 4. Item number 4.
What is this required? Yes,
The
Mr.
petitioner
Upaidya.
was supposed to file an additional affidavit, Lordship, as per
Who?
the last order, Lordship. The petitioner, Lordship.
Should not be issued directing the respondents to pay the compensation against the illegal occupation of the land measuring 4 acres. Nildan scheme by irrigation department. What is this?
Land acquisition is land acquired by the irrigation department as per the Lordship.
Did you acquire?
I have no instruction, Lordship. In fact, Lordship, there is notice has not been issued in this case. The Lordship may
notice
kindly tell you
issued?
the last order 17/11/21, Lordship.
Hmm.
The initial order, Lordship. The petitioner.
1911 the petitioner is silent as to whether during the lifetime of the state so and so or its other the state land was taken by the irrigation department by paying due compensation or not.
My friend has come.
Lordship, I am appearing. Lordship, on the last occasion, time was granted to file an affidavit. So, my lord, there isn't some communication going on my part, Lordship. Issue is, Lordship, that the land of the petitioner was taken by the department, and the department has not afforded the compensation for that particular land, Lordship. And in
Now
the-
tell me one thing.
Lordship,
Which land has been taken?
land is, Lordship, that Jamabandi, that is not clear from the petition, Lordship, but the page 12, Lordship, annexure 1,
This is a Jamabandi.
yes, Lordship, it is in Jamabandi copy.
Whose name is this?
His Lordship, that my name.
Your
is-
name is what?
Yes, my name is reflected in the page 40.
Ranjal Jyoti Bora.
Yes, Lordship, page
Your
40.
father's name is what?
Father name is the late Badan.
Late
Chandra.
Badan Chandra Bora.
Yes, his
Where
name
is his name?
is serial number 7, page 13, Lordship.
Serial number?
Serial number 7, Badan Chandra Bora.
His name has been cut out.
Yes, Lordship, because that during that period, his name was not muted. After Badan
No, no,
Chandra,
no, Mr. Besburua, kindly say. His name has been cut out, meaning thereby something must have happened for which name has been deleted. Either this has been taken out to some other patta or something else has happened. You must have sold it to somebody.
yes, Lordship.
Otherwise, it couldn't have been deleted.
Deleted, Lordship, that Badan Chandra Bora during his lifetime not muted the name, Lordship.
No, no, no. His name was inserted because he has mutilated it. It was therefore cut off, meaning thereby something has happened.
Page 14. Page 14 of the petition.
Mr. Besburua,
Lordship.
right, left, and center. I've been doing all these things throughout my life, and now you're saying this. How to read a Jamabandi? Yes.
Page 14.
Right order dated so and so. The name of 11 are inserted by name in place of respondent number 7. Patata 7. His name is Yes, your name is there at 12.
Yes, Lordship. Page 12, Pranjal Jyoti Bora.
Name of so and so are inserted by way of inheritance in place of Patada number 7 and in place of Patada number 9, the name of 13 and 14 are inserted by mutation. Okay, so this happened in 2015.
2015, Lordship.
Okay, as per the order dated so and so, the imperfect partition that a land part of so and so measuring so and so, so and so, so and so. Okay, Elizabeth. Okay, then what? When the land was acquired?
Lordship, that as per the annexure, Lordship, it was acquired on 2000 or 2000, Lordship.
And what were you doing till 2021?
Lordship, that on 2000, Lordship, I was in minor, Lordship. And my father died on 2007.
So,
And
what did your father do?
Lordship, my father has not claimed the compensation.
So now, then you became major in?
On 2021, he is aged about 33 years. Meaning thereby he is major, Lordship, in the 2015.
Then why should this court entertain a stale claim?
Lordship, the one more issue, Lordship, that father of the petitioner is also working under the department, Lordship, as an casual employee. And subsequently on 2005, his service was regularized and he died on 2007, Lordship. That is also the.
I'm not concerned with that, but why would this court reopen a thing which is completed unless you show something why it was not done? Your father never complained because your name must have entered only in 2015. Prior to that, your father expired on 2007. So during his lifetime, he never complained about it. Now, because you have inserted your name in 2015, you inserted it, knowing fully well it is a government land. Otherwise, how it could have been inserted?
And the scheme was in.
If the land has already been acquired in 2000, could that land have been mutated in your name in 2015?
The issue is also involved, Lordship.
So I think better civil suit.
Lordship.
You have no case here. Isn't it, Mr. Abel? Because isn't it, how can his name be, if the land has already been acquired? The question of his name being inserted in 2015 does not arise.
So, Lordship, liberty may be given to approach the civil court, Lordship.
Mr. Counsel,
Even
I may only say that these are disputed questions of facts. So this court is not going to entertain anything. Petitioner can resort to such remedies if so advised. But I am not going to say about liberty. The moment I say about liberty, tomorrow you are going to say, look here, the High Court had given the liberty and as such the period of limitation has expired.
one more aspect, Lordship, that I preferred an representation, Lordship.
Mr. Counsel, yesterday I passed a judgment on this representation business taking into account paragraph number 11. Representation, if a thing which is unwarranted, how can I ask for consideration? No case. You are lucky, the courts recorded such a long order for you. Heard Mr. H.W. Burua, the learned counsel appearing on behalf of the petitioner.
Lordship, I am from 1, 4, 6 and 7.
Mr. N. Upadhyay appears for the respondent number 1, 4,
6 and 7.
6 and 7. Mr. N. Usami appears for respondent number 5. Mr. R. Bopujari appears for the respondent number 2 and 3. The instant repetition is taken up for disposal at the motion stage. Taking into account the facts involved and the limited question arising for consideration. The facts of the instant case is that petitioner claims to be the owner of 4 kathas of land of Dag number 1300 of Patta number 135 of Revenue Village, Maudgaon of Moza, Sarigaon in the district of Jorhat. It is the case of the petitioner that in the year 2000, the land of the petitioner was acquired by the respondent authorities without following the due process of law, procedure of law. Was acquired by the officials of the respondent number 7 for construction of a water tank without following the due procedure of law. The petitioner on various occasions had requested for payment of compensation to the respondent number 7, but the same have not been paid, for which the instant writ petition has been filed. It appears on record. It appears from a perusal of the affidavit so filed that the petitioner is 33 years of old in the year 2021. Meaning thereby in the year 2006, the petitioner, the petitioner was a major. It is the further case of the petitioner that the petitioner's father expired in the year 2007, and the land was recorded in his name. The petitioner further states that this court was recorded in his name, and admittedly, the father of the petitioner never made any claim against the respondent number 7. It further appears from Annexure 1 to the writ petition that the petitioner's name was mutated after the death of the father in the year 2015 in respect to the said land. Meaning thereby, the said patta as well as the dag number is not a government land. Therefore, the question arises as to whether, therefore, the question that the land have been acquired by the government or the respondent number 7. Cannot be said. No, therefore, the question. Therefore, there arises no question that the land of the petitioner was acquired by the government. That too in the year 2000. When the petitioner's name was recorded in respect to the Sayin Dag and Patta number, along with others in the year 2015. Be that as it may, there might be a case of illegal possession by the respondent number 7 over the petitioner's land. Illegal possession or encroachment by the respondent number 7 over the petitioner's land. But these fall within the realm of disputed questions of facts, which this court can't decide. Under such circumstances, this court is not in a position to accede to the prayer as sought for in the petition. However, leaving the petitioner, however, However, leaving the petitioner to take such recourse to law as may be advised.
Much obliged.
At number 6 for motion.
Yes, Mr. Dasgupta.
Lord, in this time, sorry, Lord, there are some mistakes in my
Eh?
petition. Some mistakes in my petition. I prepared a note.
Then, what are you asking for?
Actually, I am asking for gratuity and pension. But what happened in Guwahati Municipal Corporation, there were 2 Nokraji. Nokraji number 1. One was a Mozdur and another was driver.
No, this is come up for motion.
Yes, Lord, actually, I have to withdraw this petition, Lord.
Huh?
I have to withdraw this petition.
Okay, you withdraw and want to refile it?
Oh, yes.
Or Mr. A.
For
Dasgupta?
that reason, I prepared that note. Your Lordship can.
I won't take it. You withdraw it now, file or refile it if you want.
I made the note.
Huh?
I made the note why I am withdrawing, Lord.
No, it's okay. You are saying that why? You are withdrawing it?
Yes, Lord.
Again, this order, he prepared a writ appeal to and so Nakaju had having code number. Heard Mr. A. Dasgupta, the learned counsel appearing on behalf of the petitioner, along with assisted by senior counsel, assisted by Ms. B. Das, the learned counsel appearing on behalf of the petitioners. Whenever you are appearing,
For GMC, madam.
Ms. S. Chutia appears on behalf of the Guwahati Municipal Corporation. The learned senior counsel submits that there are certain formal defects in the writ petition, which can only be rectified, which can only be, for which he he seeks the leave of this court to withdraw the instant writ petition with the liberty to refile by removing those formal defects. The learned counsel appearing on behalf of the respondents submits that they have no objection to the same. Accordingly, the instant writ petition therefore stands closed as withdrawn with the liberty being granted to the petitioner to refile by removing the formal defects. You keep it. It will just go. Nothing is going to happen. You keep it unless you may require those.
7,
Petitioner served as a leading fireman in the Department of Fire and Emergency Services, Assam. My Lord, he was removed from his service on 9/2/2021.
Why so and so passed by their response number 3 and appellate authority passed by response number should not be set aside and quashed? Yes. What is that order you are challenging? Where is it?
My Lord, page number
9.
43, removal order dated 9/2/2021.
43 order.
Order and appeal.
Leading fireman so and so, so and so, so and so. Discipline authority, and whereas after careful observation of his service, particularly found that he was appointed as fireman long career and during his service in ATF. Yes, now tell me.
My Lord, then review petition was filed by the petitioner, but the state review petition was rejected by the respondent number 3.
And it's a 17.
17, my Lord,
It's the appellate authority. I do not find any ground to interfere with the order of discipline authority.
Annexure 17, appellate order.
So, Mr. Counsel, I think we issue notice.
Yes, sir.
You file your affidavit. Or Mr.
M. Ahmed.
M. Ahmed,
Yes, ma'am.
the learned counsel appearing on behalf of the petitioner, Mr. D. Bora, appears on behalf of the respondent number 1, 2, 3, 4, 5. Issue notice making it returnable on. You file your affidavit by fixing it on 9th of August. Issue notice making it returnable on 9th of August 2023. As the respondent numbers 1 to 5 are duly represented, the extra copies of the writ petition be served upon the learned counsel, Mr. D. Bora, by 5th of June 2023. The case of the petitioner herein is that the petitioner is aggrieved by the actions of the respondent authority in dismissing. You are dismissal.
Yes, ma'am. Removed from service. Removed from service.
The action of the respondents in removing the petitioner from the service of leading firemen as well as also for the punishment of not entitled for not granting the salary for the period of his absence with effect from 1/12/2019. Taking into account that the instant writ petition pertains to the removal of the service of the petitioner, this court is of the opinion that the matter needs an expeditious disposal. Considering the above, this court therefore directs the respondent to file their affidavit by 3rd of August 2023. On 8th of August 2023, that date so fixed, the learned counsel appearing for the respondent shall also produce the records of the disciplinary proceedings. Hey.
Please, Your Lordship.
Yes, Mr. SD.
The petitioner is the wife of the person who had died in harness on 15th of July 2017, Your Lordship. And thereafter, she has been receiving family pension to the extent of 15%, 50% of the last drawn pay.
Pay the compassionate family pension to be equal to 100% of the last drawn pay.
This scheme was introduced in 30th of August 2022, Your Lord.
147. Page 23, Lord.
Yes, Mr. Counsel, when did the person die in harness?
15th of July 2017.
Why you approach on 10-4?
Lordship.
You approach only on 10-4 as per your representation.
Yes.
Why should this court entertain this petition? Give them some time. You were supposed to apply in the year 2017. How can you expect this court to immediately come up?
The scheme was introduced on
Understood.
in 2022, August 2022.
What was the scheme?
Lordship will find it at page number 23.
What is this?
Lordship, it was an amendment to the family pension rules, Your Lordship, the Assam Services Pension Rules. And
What does it say about compassionate family pension?
family pension, a person who dies in harness, Your Lordship.
That is already there from 14/7/2017.
Lordship.
Then
Now she would be entitled to 100% of the last drawn pay.
that is what already there from 14/7/2017. Who says it is not there? It was already there, isn't it? Anybody from pension expertise? Mr. Borbuzari, the compassionate family pension. Mr. Hassan is already there from that date. Then kindly, Mr. Day, don't come up with these type of excuses before this court.
Earlier it was 50%, Your Lordship.
No, it was 100% from 14. That is why the compassionate family appointment is not being given granted. Isn't that the scheme? Now this has been brought into the rules by way of an amendment. Otherwise, what was it? That is why you are entitled from 2017. If the amendment was brought into effect on 30th of June 2022, how you would have got it? Tell me. You couldn't have get it. Why it was given retrospective effect? Then why have you approached so soon? This court is not going to issue notice on it. We dismiss it with a cost upon the lawyer. You file after 3-4 months, then we'll look into it. Not early. And take it up with these people.
Lordship.
And cost upon you, how much?
Lordship, I may be allowed to withdraw in that.
Okay, well, you are withdrawing, but you have to pay the petitioner a cost from your pocket for indulging into unnecessary litigations, for advising somebody to indulge in unnecessary. You should have asked them to wait. 50,000? 50,000 upon you.
No, Your Lordship.
I'll keep the matter only pending out here to see as to whether you have paid that. Take a receipt from your bank to the petitioner's bank account transfer. Then that receipt, we'll look into it.
We condone that, Your Lordship.
Huh? No. Why have you advised the petitioner to approach in such a... You have, after all these years, and Mr. Dey, you know about this fact Are you saying that you don't know about the family compassionate family scheme which came in 2017? You didn't know what has happened in 2018? Then there was an amendment which was made in 2018? I always treated you that you knew what was there in the law. Or are you giving me an impression that you don't know what is there in law and you have only for the first time come up before this court, except the matters pertaining to overdue and overdrawn or long drawn or overdrawal of overdrawn this, what do you call, stay and all? You are not aware about these aspects? No, Mr. Counsel, am I to understand that you are not aware? I'll excuse you. But am I to understand that you are not aware that there was a notification in the year 2017? It was followed by an amendment in 2018. And then it was incorporated within the fold of the act by this thing because it was required to be done. Otherwise, those people were not getting it.
Lordship, but it did not mention, there is one of 2017, Your Lordship, 31st October. This did not mention about the 100% pay.
Who says 100% it is not given? It says the last drawn wages till the date he gets the age of retirement.
100%.
Then, are you saying this? So you have two options. Either pay costs or this court will presume and assume that from now on we can't take you for whatever you say.
Lordship, honestly, this is the first pension case I have appeared in.
Huh?
This is the first pension matter I have appeared.
Fantastic. So we admit, we'll take it that you don't know. Withdraw. Approach the authorities. Come after some time. Don't come. But is Mr. Bhattakur not aware?
It was actually filed by one.
Did he sign the wakalatnama? And these type of matters we don't expect from some. Yes, some lawyers will do it, but we don't expect from the seasoned lawyers out here. Did he sign the wakalatnama?
Yes, sir.
Oh, he doesn't know. Then Mr. Bhattakur, the opinion now the court which will hold upon him. We have a black book. Now I am thinking of having a grey book in respect to persons who don't know. What do you intend to do? Heard Mr. S. Day, the learned counsel, appearing on behalf of the petitioner. Mr. N. Upadhyay appears on behalf of the Irrigation Department. Mr. D. Bora appears on behalf of the Director of Pension. Mr. Argus Gorpujari appears for the Finance Department. And Ms.
Finance is not a party.
Yeah, SC Finance has been made a party.
It is there, perhaps they have wrongly.
This is Finance and Accounts Officer, house paid pension. No, he's not a party. Your name? Accountant General is here?
Yes, Lord.
So and so appears for the Accountant General. The instant writ petition has been filed by the petitioner claiming benefits under the for compassionate family pension. On the ground that the petitioner's husband expired after 1/4/2017. It, however, appears from the records that it was only on 10/4/2023 the petitioner had approached the respondent number 4. The petitioner have also not approached the respondent number 1 by filing a representation, which is also required to do so. Considering the above, the learned counsel for the petitioner therefore submits that the petitioner may be permitted to withdraw the instant writ petition and take recourse before the authorities concerned by by bringing into the notice of them, the said authorities, that the entitlement of the petitioner in terms with the notification dated, that is 14/7, na? 14/7/2017, 14/9/2017, which came into effect from 1/4/2017, as well as the Assam Service Bracket Pension Amendment Rules 2022. This court further finds it relevant to take note of that the submission of Mr. N. Upadhyay, the learned counsel appearing on behalf of the Irrigation Department, who submits that if the petitioner approaches the authorities, they would definitely consider in terms with law. Considering the above, the instant petition therefore stands closed and withdrawal. Liberty is, however, given to the petitioner in the circumstance the authorities do not act on such representation to be filed after a reasonable period.
Obliged.
Item 9.
Mr. Day, next time,
I apologize.
it's a case of cost upon the lawyer.
Obliged.
Yes, Mr. Khan.
Yeah, this is again a suspension lordship. The petitioner was suspended with effect from his date of arrest on 7/9/2022.
Then,
Thereafter, lordship, no departmental proceeding has been drawn against the petitioner. Lordship, nor the lordship order has been recorded.
you got bail on 31/11/2022.
My lord,
Then when did you inform that you have got on bail?
my lord, that is space lordship 28. Lordship.
28.
28, my representative.
That was received on 16/3.
3, yes. Okay.
So time is not over.
My lord, that
Time not over. At least wait for 3 months.
lordship, he was placed under suspension.
I am not concerned with those. You were placed under suspension because you were inside the jail.
My lord.
Thereafter, 48 hours is gone, then you are to inform them authorities. Do you want those disciplinary authorities to be watchdogs outside the jail? Oh, when Mr. Khan is going to come out, I will issue the show cause to him. You have to intimate him that look here, I am out, do something.
But that
And from then the notice will be taken.
was done, but they should take it into account from the date of arrest.
Chalo, if you want, I will dismiss your petition.
Lordship.
What do you want?
The notice to issue,
Huh?
notice to issue, Lord.
For what? 16/6, na? You know what to do. Huh?
Yes, Lord.
You have been successful in doing that. Once I issue notice, you know what happens. They come to know your action. And then they will take the steps. Your entire cause of action will be gone.
Done.
You want that notice? I can put it, no problem.
But simply, Lordship, this may be listed, Lordship, after 16, Lord.
Yes.
Without it.
I'm coming in 15 minutes. Think about it.
Is the suspension order. The procedure of the commissioner. Email.
Mr. M. Khan, the learned counsel for the petitioner who submits that the instant matter be taken up after 16th of June. Accordingly, let this matter be listed again on 19th of June. You do the needful.
Deputy Commissioner will do. Deputy Commissioner will do.
You know what to do.
Number 10.
Number one, my lord, is wife and when we have minor children, my lord. The respondent 5, my lord. Ella Ludin Ahmed, who retired from 31st of March 2023. My lord, now, my lord, they are praying for increasing their name, my lord. The service record of their father.
What has happened?
My lord, now, my lord, although they have submitted their resolution, my lord, for inclusion their names, my lord, the service record of their father, my lord, their names have not yet been included.
Whose?
My lord, Hela Lutin Ahmed, Hela Lutin Mondul, my lord, this number 5.
No, tell me, you are who?
Well, petition number 1 is wife, second wife,
Okay.
and 2 and 3 are the children of the second wife.
Then?
None, therefore, my lord, they were living separately, my lord. Subsequently, my lord, maintenance chance was registered and maintenance was also provided by the court, and he is still paying.
Who is the petitioner? Respondent number 5 and 6?
5 is the, my lord, husband, my lord, and 6 the first one.
So it is a dispute between you and 5 and 6.
My lord.
Why this court should interfere?
My lord, only, my lord, the service record, my lord, for including their names in the service record, my lord. These the children of the second wife is also eligible for pensionary benefit, my lord, if certified.
Their benefit will only arise at a later stage.
My lord.
And that is as per law.
My lord.
This person is very much alive.
My lord.
Then, before he dies, you want to incorporate all these things. Talk it up with 5. 5 is not willing. By the time petitioner, 5 is, what is his age of 5?
My lord, 61 years.
He's retired.
My lord.
He's getting pension.
My lord.
Then you want his death.
No, my lord. I'm not. But in fact, something happens, my lord, then they will be.
Then how does petitioner number 2, petitioner number 1 will have a right? Being the second wife, he will have a right.
Right.
But that right is subject to all. If they are not done as per this, you whether you come within the family or not, that will be considered at a later stage.
My lord.
Why does this court have to do it?
My lord.
As of now, the authorities, is it the requirement as per the year that everybody's name has to be included in the pension PPO? Only one name is included.
My lord.
Then
But as a service record, my lord, if their name is recorded in the service record, my lord, that would work, my lord.
so isn't it too premature?
My lord, petitioner number
Yes, Mr. Khatunia.
Yes, my lord.
Isn't it too premature?
And in fact, they are getting maintenance, my lord. On the basis of maintenance, they are now trying to include their name in the survey group. That too after his retirement, my lord. The person has already been retired, my lord.
If you have any problem with the pension not getting it,
Yes,
and
my
you want to show it before the authorities then. As of now, you are not entitled to.
As of now, no, I'm not yet.
Then-
It's a-
You see, as regards petitioner number 1 is the second wife. You have the full bench judgment. The second wife cannot get it till the first wife is alive.
Yeah, like-
She may have a claim, and this claim will be subject to adjudication before the appropriate forum.
Right.
So 1, this court can't do it. 2 is 16.
Right.
He's yet to, his father is yet to die.
Right.
Then 3 is 12. He may have a right at a later stage. Those rights will be done at a later stage. How can you do it now? In fact, it is the authorities have no problem out there.
No, no.
You are asking a writ against the respondent number 5 and 6, 5 more particularly,
Yes, in fact,
so that the 5 has to submit the details.
yes.
Without 5 submitting the
That is
details,
right.
can the authorities act on it?
No, my.
Then
So, my lord, in fact, my lord,
you want,
my lord.
like Mr. Khan waited till 16, you want
No, my lord.
this matter to be adjourned sine die till he dies?
No, my lord.
Then something to the effect.
In fact, my lord, what I'm submitting, my lord, in fact, praying also, my lord. Since the respondent number 5, my lord, is a father, my lord. My lord, may I pray for issuing notice, my lord, to him, my lord. May I pray for issuing notice to him, my lord. Respondent 5, my lord.
Why?
First, my lord, so that he can incorporate his, my lord.
Absolutely no. That is a dispute between you and everybody. I'm not going to do that. Go to the civil court if you are entitled to.
Yes, yes, well, my lord.
But this is not a dispute out here which can be
Right.
resolved, whether you are entitled or not. Now, you see, Mr. Hawk, na?
Yes, my lord.
Yes. Mr. Hawk, tomorrow, you are entitled to. Obviously, you'll come within the ambit of it. You will obviously take out a next of kin certificate.
Yes.
Would without a next of kin certificate, on the basis your name is there in the service book, can it be done? No. You have to have a next of kin certificate. Take out and show it to the authorities. If you are entitled to, you'll get it. Heard Mr. S. Hawk, the learned counsel, withdraw, dismiss, which one? Will dismiss. Premature.
Right.
Say premature.
Right.
Heard Mr. S. Hawk, the learned counsel, appearing on behalf of the petitioner. Mr. N.J. Khatani appears on behalf of the respondent numbers 1 to 4.
Wonderful.
Taking into account the facts involved and the legal points in issue, the instant petition is taken up for disposal at the motion stage itself. The case of the petitioner's hearing is that the petitioner is the second wife. Number 1 is the second wife, and the petitioner number 2 and 3 are the
Minor citizens.
minor children. Is the second wife of the respondent number 5.
Right.
And the petition number 2 and 3 are the minor children born out of the wedlock of the petitioner number 1 with the respondent number 5. The grievances of the petitioners is that their names have not been included in the service book. Admittedly, the respondent number 5 had already retired. This court made a specific query upon the learned counsel for the petitioner as to why the names need to be included. More so when, if a right to pension arises at a later point of time, it has to be on the basis of a next of kin certificate to be submitted before the authorities concerned. This court further inquired. The learned counsel for the petitioner submitted with all fairness this, that without the next of kin certificate being submitted upon the death of the respondent number 5, the petitioners cannot get the benefit of the pension or the pensionary benefits. Under such circumstances, this court is of the opinion that the instant writ petition is primarily a dispute between the petitioners along with the respondent number 5, who is not willing to incorporate the names of the petitioners in the service book. This court is also of the opinion that the right of the petitioners to get any benefits would only arise upon the death of the petitioner respondent number 5. And as such, the instant writ petition is premature. Considering the above, the instant writ petition stands therefore dismissed. However, the petitioners, if so aggrieved, the
11.
last line, if I put it would so that you are anxious that when your father dies, it will portray poorly. Yes, Mr. Hussain.
This petition file against the impugn letter annexure 7 page 30 by which
Excess.
withdrawal of the mallet gratuity from the benefit of the pension. Well, if your lordship for a moment, just I'm taking 2 letter from the accountant general office, annexure 8 matter, annexure 1 page 18 matter.
There has been excess withdrawal for why? Wrong fixation.
Now they in the impugn order due to technical error, what has been paid,
Mr. Couch.
Yes, yes.
The question to you is very
Wrong
simple.
calculation.
Is it because of wrong fixation?
No, wrong calculation.
It is no this way or that way, one and the same. The authorities have made wrongly calculated, and you had no hand on it. Did you? Were you the person responsible for calculating? So under such circumstances, you come within the ambit of Rafiq Masih.
My lord, here it is not the case of wrong fixation of pay or overstay, my lord. Here, my lord, there is a case of, my lord, wrong calculation of DCRD amount. Lordship may kindly peruse page 30, my lord.
Yes.
Page 30, annexure 7. The last portion of the letter, my lord. Due to some technical error, rupees so and so, being gratuity was wrongly authorized by GPO number so and so, instead of admissible amount of 7 lakhs. So this.
How much amount did you pay?
8,30,594.
It should have been
7 lakhs.
Now, from where they calculate exactly, I am taking here 2 documents, rather 3 documents.
Where?
Page 17, Miller. Now take page 18. This is the amount, Miller, DCRD. 6,76,253. Lordship in the top. Now this was paid, Miller, followed by annexure 2, page 19, Miller. Roman 4. Gratuity amount of 8,30,594 in lump sum less already drawn this what I have just referred, Miller. So therefore 6, Miller, Roman 6. I therefore request you to make necessary arrangement to payment of area revised pension as stated such and such. Area's revised pension also paid with effect from such to date, and last payment and the balance amount of DCR. This amount has already been paid. Now thereafter, my lord, I filed a writ petition before this honorable court, claiming, my lord, promotional benefit as well as the consequent area borne out from the promotion as a deputy conservator of forest,
during pendency of this, along with some increment, during pendency of this writ petition, my lord, they paid all this. And 2 prayer was that not considered during pendency. During pendency, this annexure 3 page 20, government has, my lord, creating a supernumerary post, my lord, giving me promotion with retrospective effect, my lord. Last 2 penultimate and last paragraph. Now, therefore, subject to the revision without notice, assigning any reason thereof, Governor of Assam is pleased to promote such and such assistant conservator to the rank of deputy conservator of forest under rule such and such with a scale of pay band such and such, grade pay such and such with effect from 26/10/2010 till retirement.
So this is the benefit which you got because of that, and as such it became 8 lakh.
Exactly. When this, following this order, this honorable court pass an order, my lord, annexure. Now,
In view of the above made on the so the direction to respond to work out the views of the petitioner, if any, with respect to prayer number 3 and Mia are concerned.
because other prayers
Reference
already.
to so and so.
Now,
Exercise shall be completed within 8 weeks. So it is in pursuance to this they
this
paid.
order, my lord, instead I have filed a representation along with this order. Instead of, my lord, gave the revised, my lord, payment of the gratuity,
They reduced it.
They rather reduce this. Now I take a letter surprisingly, my lord, page 29 annexure 6. This is the, my lord, salary statement from that period as per honorable court directions. 26/10 to 30/10/2011. That is written. Now already drawn is this amount, 54,762 per month. To be drawn, my lord, as per their sanction, my lord, as per to be drawn is to be, my lord, 59,658. Rather, I entitled to get more. Now, from where they calculate exactly the round figure 7 lakhs and reduce 1,30,000 something or amount, my lord, from my pension.
Now you have got your pension.
Well, yes, getting the even reverse pension till date, my lord, April, getting.
But you are only
Exactly. This only the challenging this impugn order, my lord, the excess, alleged excess withdrawal deduction.
Chal. Heard Mr. A.K. Hussain, the learned counsel, appearing on behalf of the petitioner. Mr. S.M. Hassan appears on behalf of the respondent number 1, 4, 5. Mr. R. Bopuzari appears for respondent number 2 and 6. Mr. A. Hassan appears for respondent number 3. Issue notice making it returnable on 7th of August 2023. August 2023. As the respondents are duly represented, extra copies of the writ petition be served by 5th of June 2023. The petitioner herein is aggrieved by the order dated 14/12/2022 issued by the senior accounts officer of the Office of the Accountant, Principal Accountant General AE, whereby it was mentioned that the total entitlement of the petitioner on account of gratuity was ₹7 lakhs, and the petitioner has already drawn ₹8,30,594, and as such, an amount of ₹1,30,594 is required to be recovered from the petitioner. The learned counsel appearing on behalf of the petitioner has drawn the attention to the annexure 1 of the writ petition, wherein the senior accounts officer, Office of the Accountant General AE, has mentioned that the total DCRG to be rupees 6,76,253. Thereupon, on 21/9/2020, the said officer had mentioned that in view of revised pension, the petitioner would be entitled to rupees 8,30,594, less the amount of rupees 6,76,253, which the petitioner have already received. And accordingly, there was a direction to the Treasury Officer, Bongaigaon, to make payment of the amount of rupees 1,54,341. The learned counsel further has drawn the attention to this court to an order dated 17th of August 2022, wherein there is a direction by the Additional Chief Secretary to the Government of Assam Environment and Forest Department, whereby the petitioner was promoted to the rank of Deputy Conservator of Forest with effect from 26/10/2010. The petitioner, in the meantime, it is also relevant to take note of that the petitioner filed a writ petition before this court challenging the entitlement, challenging the action of the respondent authorities in not granting the petitioner the appropriate entitlement to which the petitioner was entitled to. This court, by an order dated 24/8/2022, after taking into account the order of 17/8/2022, as already stated here in above, dispose of the petition with a direction to the respondent authorities to work out the dues of the petitioner, if any, with regard to prayer number 3 and 4 of the writ petition, in deference to the order dated 17/8/2022. It was further directed that the said exercise be completed within a period of 8 weeks from the date of the said order. The legal counsel for the petitioner submits that on the basis of the order dated 24/8/2022 passed by this court in WPC number 1511/2020, the petitioner is entitled to a higher amount. However, the respondent authorities have issued the impugn order whereby they have sought to recover an amount of rupees 1,30,594 on the ground that there was an excess amount paid on account of DCRG. Taking into account the above facts, this court directs the respondent in the office of the Accountant General, AE, to file an affidavit as to whether the said order dated whether the impugn order dated 14/12/2022 was passed after taking into account the order of promotion dated 17/8/2022, as well as the order passed by this court on 24/8/2022 in WPC number 1510/2020. This court further is of the opinion that the petitioner have been able to make out the prima facie case for grant of a stay to the impugned order dated 14/12/2022 insofar as the recovery of the amount of rupees 1,30,594. Accordingly, this court further directs the respondent authorities not to deduct the said amount of rupees 1,30,594, deduct oblique recover the amount of rupees 1,30,594 from the petitioner or from the entitlement of the petitioner.
I have been told by petitioner, but perhaps his calculation has already been,
Huh?
it has already been deducted from its pension, area pension.
I can't give you that it has been.
That is fine. High level.
Well, if not deduct. But Mr. Hussain, if it is deducted, don't you think you are to ask for recovery?
Well, since the deduction is the primary is the illegal, they have to return back.
Understood. Don't you think that there should be an order because your prayer was pending not to deduct?
No, well, direction, my prayer also there there is a prayer
For?
whatever already been deducted, the direction to refund the.
Or there is a prayer.
There is a prayer.
But is it your case that it has been deducted?
My lord.
You have stated.
My lord, is stated.
Okay,
My lord, please to direct the respondent authorities to immediately release alleged excess amount of so and so which was deducted from his pensionary.
Detail last line to tell obtain
direction
instruction on like and file an affidavit as to whether the or impugn order was passed in terms with by taking into account no interview. Yes, Mr. Counsel.
Well, this matter relates to a non-payment of salary. The petitioner.
Non-payment of salary.
Yes, Lord.
Form.
For my lord, as a non-allotment of GPF account. For payment of salary was stopped. My lord, you also kindly page 22 and
Page?
Page 22 annex 3, my lord. That is why the payment of salary was stopped, my lord. There is next statement. It is the instructor of the school letter returned to the director.
Then?
Then my writ petition was filed, my lord.
Then what happened?
Writ petition was filed, page 28 and 36.
Then what happened?
Then my lord, page 31.
In dispose of directing the authorities, more particularly to resubmit the application for opening of the GPF account of the petitioner along with the relevant documents to the office of the accountant with the
And that has been done, my lord. And my lord, the GPF account number allocated, my lord. Page 39. Page 39. In terms of the order filed by this honorable court, my lord. Page 39 and it's 12.
Yes.
Then the VED number 294-698 and the representation has been filed before the respondent manner directive to release the salary but not yet been released. Nothing has been done. Page 40 manner and 13 manner is that.
Then?
But not yet, my lord. Salary paid, my lord. Salary as well as area as well as current. Nothing has been done.
Let me issue notice.
How the inspector of school can regularize
Exactly.
somebody from the date of their joining?
That is there. In fact, my lord, the initial appointment was also, my lord, ad hoc basis.
Yes,
They-
but and regularize from the date of their
Date of
joining? Is it power is there?
Oh, my lord. Right.
How are these things possible? Why are you not taking any action against these people?
Letter was done in the 2009, in the year 2009,
Understood, but 2009 also, if it is done.
but it is accepted by the government.
And who is the DDSC? Director, the district, what is this, DDSC?
It is a deputy
The
director.
Deputy
Deputy
Director of Secondary Education.
Deputy director secretary.
Is this the manner in which he submits?
She was transferred from North Lakhimpur to Nalbari, my lord. Initial appointment was ad hoc basis for 3 months. And the transfer order is also not annexed with the writ petition, my lord. And subsequently, my lord, by Annex 3, her service was regularized.
Third, Mr.
PV Modi.
P.V. Majumdar, the learned counsel for the petitioner. Mr. N.J. Khatonia appears on behalf of the respondent numbers 1, 2,
3, my lord, 1, 2,
Three.
and 3.
Mr. R. Babujari appears for respondent number 5. You're still working.
Yes. Still on.
Issue notice making it returnable on 11th of August 2023. As the respondent numbers 1, 2, 3, and 5 are duly represented, extra copies of the writ petition served by 5th of June 2023. As regards the respondent number 4, steps be taken by way of registered as well as usual. Good stop. The case of the petitioner herein is that the petitioner was initially appointed on ad hoc basis in the Laluk HS school under the Lakhimpur district by the then Inspector of Schools, Lakhimpur, by an order dated 9/6/1994. The said service of the petitioner was extended from time to time. During this ad hoc service period, the petitioner was transferred from Laluk HS School to PB Alia High School on 16/9/2000. It further appears that the petitioner services was regularized as assistant teacher Arabic by the then Inspector of Schools NDC Nalbari by an order dated 22/12/2009. In doing so, the Inspector of Schools Nalbari had regularized the services of the petitioner from the date of her joining. It further appears from Annexure 11 to the writ petition that the petitioner received her salaries till 31/12/2005 and thereupon the petitioner did not receive the monthly salary due to non-availability of the GPF account. It further appears from the record that this court, by an order dated 38/2019 in WPC number 352/2018, directed the respondent authorities, that is the Director of Secondary Education as well as the Inspector of Schools to resubmit the application for opening of the GPF account of the petitioner along with all relevant documents to the Office of the Accountant General AE Assam within a period of 4 weeks from the date of receipt of the certified copy of the order. It was further directed that upon receipt of the said proposal, the Office of the Accountant General AE would do the needful so that the GPF account of the petitioner can be opened without any further delay. It further reveals that on 19/5/2020, the Inspector of Schools NDC Nalbari issued a communication to the Director of Secondary Education Assam thereby forwarding the letter received from the respondent number 4 for opening of the GPF proposal in respect to the petitioner. Thereupon, the Deputy Director of Secondary Education had passed an order on when?
Date is real, my lord, but actually.
No date.
Was given by.
Had passed an order as could be seen from Annexure 11.
Yes.
Stating inter alia that the regularization of the service of the petitioner has been made by the Inspector of Schools Nalbari by order dated 22/12/2009 with effect from a date of her joining. That is on 10/6/1994. Which may be considered as the date of regularization of the service, and the Accountant General AG was informed. It further appears that the Office of the Accountant General AE had issued a communication to the Inspector of Schools Nalbari dated 24/9/2021. Wherein it has been mentioned that the GPF account of the petitioner was opened with effect from 21/9/2000. The case of the petitioner herein is that as the petitioner had services was regularized with effect from 10/6/1994, and the petitioner had only received the monthly salary up till 31/12/2005. The petitioner is therefore entitled to receive the salaries with effect from, and other allowances with effect from 1/1/2006. The respondents are directed to file their affidavit by 7th of August. The respondents are directed, the respondents in the elementary education, secondary education department, the respondent is directed to file the affidavit as regards the entitlement of the petitioner on or before 7th of August 2023 without fail. Mr. Borbujari, you are filing affidavit?
I am the treasury officer. So the quantum calculation, everything has to be made by the administrative department. And on the basis of this, my lord, the AG will issue the mandate. I will execute.
won't you say anything on the retrospective regularization which has been made from a particular date? Because wouldn't it touch upon the regularization of your notification whereby a person who comes after 1/2/2005 would not come within the ambit of the GPF?
Then perhaps my lord may be pleased to impeach finance department as a party.
Let him file.
My lord, in the interim, my lord, the current salary may be.
Huh?
In the interim, my current salary may be paid, my lord, to the petition.
He is before this code after 23 years.
No, he has come in 2019. Why didn't you ask in the earlier round of litigation for salary?
Yes, I asked.
Then why was it not given?
Not given when the court said that since the salary was stopped for non-allotment of, so they are ready to pay your salary. So you get this allotment number, GBF number. So
I'll say that the interim order shall be considered on the next date after perusal of the affidavit so filed by the secondary education.
Obligation.
13.
In here also matter relates to non-payment of salary. The service of the petitioner has been provincialized, your lordship, on 5/2/2021, and thereafter the petitioner joined on 6/2/2021. And since then, your lordship, the petitioner has not been paid.
Not a single penny.
Not a single penny.
You work where?
As tutorial, lordship.
Huh?
As tutorial.
What is the school?
Motikwa LP school, your lordship.
Motikwa MEM school.
LP school, your lordship.
MEM.
LP, your lordship.
LP. So tell me one thing, how many you approached earlier?
Yes. That is a space, your lordship.
It's 23.
23 years.
What is this order of Justice Budor Burwa?
That order in the one of the assistant teacher of the petitioner, your lordship, filed this petition, and it was disposed of on 16/12/2020, was prior to the issuing provincialization order, your lordship. And herein the issue was the name of the petitioner was not provided by the. He made allegation. The petitioner, present petitioner, he was the headmaster of a Panther educational institution, and the issue was the headmaster, that means the present petitioner, he did not provide the name of the petitioner before the DLS, before consideration of this case, and accordingly this order was passed. But there was no any order from any court or any authority restraining them from releasing salary of the petitioner. And this
Heard Mr.
A.M. Khan.
A.M. Khan, the learned counsel for the petitioner. Mr. B. Talukdar appears on behalf of the respondent number.
All respondent.
Of all the respondents. Issue notice making it returnable on 19th of July 2023. As the respondents are duly represented by Mr. B. Talukdar, extra copies of the petition be served upon him by 5th of June 2023. The case of the petitioner herein is that the petitioner was that by an order dated when Where is the order?
Annexure 1 yellow.
By an order dated 5th of February 2021. Your name is? The petitioner was, the services of the petitioner was provincialized
Yes, Tito.
as a tutor in Motikwa ME Madrasa. The petitioner thereupon have not received a single penny as salary. Full stop. The respondents in the elementary
Yes, Philip.
education department is directed to obtain instruction as to why the petitioner have not been paid his salary upon his provincialization by the order dated 5/2/2021.
There is an interim order there of interim is also there, your lordship.
For what?
The current salary is your lordship.
That I can't. At present, it is not possible.
On the next.
On that day,
Yes.
let them get instruction.
Mine.
Shall obtain the, yeah. It is further mentioned that as the petitioner have not received his salary, the respondent council, the respondent in the elementary education department shall obtain the instructions so sought for without fail.
53.
One of the petitions, my lord, were working as outsourced meter readers. An earlier round of litigation was there where they come up for praying for regularization of their services. This honorable court, my lord, made a difference that who have completed 10 years in terms of Uma Devi, for them regularization be made. And for the others, my lord, it would be the minimum scale of pay. Accordingly, my lord, we approved that order went to the authorities. And first they were about to give it to us, my lord. They agreed to give it to us. Now they have passed the speaking order saying that we can't do it because it would be a great financial burden. My thing is, my lord, when in all those cases when the regularization was being considered, court took a plea line that we cannot burden the state with this, saying that we cannot burden the state with this financial thing. But my lord, at the same time, they say that you cannot deny a person from the minimum wages that are there for a regular post. So these two things are there, and it has set a violation of Article 14. So, my lord, this order requires to be, my lord, examined. That order, my lord, would find at page 98. 99, my lord, would see just after the name. The APDCL, in terms of the order dated 23/2/21, had initially decided to grant benefit to the petitioner in the said petition. However, in the meantime, several other writ petitions were disposed of by the Honorable High Court, and it was found that numbers of petitioners claiming identical relief altogether numbered to more than 800.
You are contractually appointed?
We are contractual. And we are doing the same work, so there is no dispute. They have not disputed that.
But can you equate yourself with the?
Yes, my lord, because after the decisions in that Singh and all, there is a line, my lord, which says that if the work is same, if there is no dispute on that, you can, you must. Otherwise, it will be Article 14. Here, my lord would be that they have not even disputed that we are not doing a work which is of the same level as that of a regular employee, or we don't have that qualification. These are not disputed people. That's what I had examined, my lord, and I found that they are not disputed.
But Jagjit Singh, later on with the judgment of
18,
2019 SCC page 301.
But even therein, my lord, that question was left open and the Jagjit Singh was followed, my lord.
No, but if you see paragraph number 96.4.
96.4 of that 2019, my lord. 2019 12 SCC 297.
2019 18 SCC page 301.
State right.
They have a lot of resources.
And my lord, that judgment of Upendas would also apply. And they try to say that that is for the state, not for us. But Upendas, my lord, cannot be made.
But the direction was Upendas was only for state.
But they are a state entity.
That was for state government.
Right, my lord, but they are also state entity that spirit can be put.
Tomorrow are we applying Upendas to Bihar?
No, no, no. I'm saying, my lord, in the state itself. There are
Also, my lord, in the petition, there's a prayer to restrain the corporation from doing away with the services. No, but no such material has been appended and we are not taking any such action. They will work till their contract terms and till superannuation. Interim, my lord, not to disturb the service of the petition.
Well,
96.
96 month. Analysis. Equal is not an abstract, has no mechanical application in every case. The very fact the person has undergo a process for recruitment itself in certain cases make a difference. The application of so and so. Normally, the applicability of this principle must be left to be evaluated and determined by an expert body. Granting pay scales is not on pay scale. I'm not on the pay scale.
No. On pay parity.
Paper. I'm not.
Then kindly come to 96.10.
In a given case, a mode of selection may be considered as one of the factors which may, nothing of that. I'm not even disputing that. What I'm saying is I'm not on the scale. I'm only on the minimum of that scale.
But that is what.
But this judgment, my lord, does not prevent us. Or, my lord, if they had taken that plea, in the speaking order while rejecting my case, that you are not similarly situated like them. They have never taken that plea.
They say we don't have the money for that.
That's a different aspect altogether.
That is what of the one, that is 96.4 or 5, it says. Cascading effect.
Granting of pay scale is an purely picture and hand should not. It may have a cascading effect, creating all kinds of problems for the government and the authorities. But I don't want the pay scale. I am not entitled to the pay scale.
No, the minimum of the pay scale.
That's my right, Madam.
That's not right. How can that be a right if the source of employment is different? That is what has been stated later on.
If that was the plea taken, that the source of employment is different and you are not entitled, then, my lord, fine, no issue on that.
Do you want that they should also have some people, officers from the court out here sitting out there for passing orders? You have to look into administrative orders in the sense.
But, my lord, here, my lord would find they gave it to us.
Huh?
And they gave it to us. It was authorized to us, my lord. Then they say many cases have been filed, so we are not. So that means we fulfill all those conditions.
Maybe, but
because of the financial burden they are not giving.
They don't have the money.
No.
Tomorrow you may not get electricity if they have to pay you.
15 paisa each.
Chalo, we'll only issue notice.
Only notice I'm paying for.
Nothing more. Mr. UK Nair, the Learned Senior Counsel, assisted by Mr. MP Sharma. Mr. You are?
For the APDCL, all the respondents.
You have left forest?
I'm there, my lord. Today, Mr. Pathak is not there.
Okay.
I had to step in.
Mr. D. Gogoi appears for respondent number 110.
Multiple.
Issue notice making it returnable. You file your affidavit. Huh? Issue notice making it returnable on 11th of August 2023. As the respondents are represented by Mr. D. Gogoi, extra copies of the writ petition be served upon him by 5th of June 2023. The case of the petitioners herein is that they were recruited to the services of the respondent number 1 corporation. A respondent number 1 company, which is a state within the meaning of Article 12 of the Constitution, as contractual, on contractual basis. The cases of the petitioners is that the petitioners are entitled to, the petitioners herein may not be entitled to the pay scale which is being given to similarly situated regular employees of the respondent of the corresponding rank. But the petitioners are entitled to the minimum scale of pay. It is the first case of the petitioners as that the respondent authorities, though, have agreed that the petitioners meet the criteria, as could be seen from the speaking order dated 21/3/2023. But on account of financial incapacity, the grant of the minimum scale of pay have been deprived to the petitioner. The said order and the decision of the respondent authorities have been put to challenge by way of the instant petition. The respondents are directed to file their affidavit by 4th of August 2023. The petitioner would be at liberty to file their reply by 10th of August 2023.
We had raised an apprehension that we may be ousted. My friend says there is no such apprehension to be done. They are not deciding. That can be recorded, my lord. We be on the safer side.
Denied.
He has said I have full faith on it.
You show the recording out there. He said, we have the archive.
Double-edged sword, my lord. These days.
I have 14 for admission.
Lordship, this is a pension matters to the first wife. Pension matters to the first wife.
I need 2 weeks time, my lord, to file affidavit in
Lordship,
opposition.
it is long pending case, 2019.
They are-
Destitute lady has not been getting anything.
You are first wife.
First wife.
You are?
Second wife, my lord.
So you admit it. Then how, what affidavit is required?
Otherwise, my lord,
I'll give you the affidavit. You pay the
Yes,
pension.
yes.
You pay the pension to her.
He is not the
You want
she is surviving by this pension only, my lord. She abandoned,
you have to-
deserted the wife, my lord, first wife.
Who?
First wife was deserted my husband, late husband. 84. Thereafter, marriage was solemnized 2008. Thereafter, he expired, my lord. From 84, 30 years, there was no communication. Immediately after his expiry, my lord, this case, my lord, comes, my lord, in the year 2019, my lord. 30 years, no communication.
It is not so.
And that's,
He is getting, she is getting, today itself, in the morning time, I
do
asked.
you agree that she is the first wife?
Yes, yes, I agree. Agree, my lord.
Do you agree that there was no divorce?
That has to be, my lord, I have to check out the, my lord.
No, I'm asking you, you know it. You were not engaged yesterday because earlier also you have
Yes, my-
appeared.
yes.
So you know it. Was there a divorce?
There was no divorce, my lord. Earlier there
So
was not,
what
but
is your right?
Well,
You are the second wife.
second I contact.
That marriage is a nullity.
Exactly, my lord.
Then
2008, my lord, onwards, I am along with him, my late husband, my lord.
so maybe
Subsequently, my lord, our marriage was solemnized, and once on, he is now in class 7, my lord. So today she has informed me that if it has to be stopped, I have informed her that it may be stopped, your pension. Then I have to, my lord, without the pension, I cannot survive, my lord.
Mr. Das, I think you should advise your client to part with a part of, else you lose everything.
She deserted me, but the law is that
Okay, if you want if you want a decision, it is going completely against.
Yes.
So you lose to get.
And
You are not entitled to a single penny.
In papers also, my lord, papers also.
If you were a Muslim, I could have said that you may have a right of something. Better off, why don't you share half of it?
Yes, yes.
No, Lordship,
Yes,
10 years
madam.
he has already enjoyed. The husband died in the year 2014. Today is 2023. 10 years he has already enjoyed the pension.
Understood, but why didn't you file your petition 10 years before?
Lordship, this is a destitute. He doesn't know. She had been filing petition.
Because you didn't know your husband died.
No, she performed the regular ceremonies also, death ceremonies also. She performed that.
And then why didn't you file the petition then? Why did you
She was
file it in
she was filing
2019?
She was filing application before the authorities.
When did you file?
2014, sir.
Then?
2014, she was not advised. In fact, she was not
So
advised.
they didn't get you.
Lordship, she was not advised that she should file it because the authorities were, she was hoping that authorities will do needful.
Both of you share it.
Yes, yes.
Better off.
I'll share.
Sharing will be.
That will be better.
You have not got any penny.
Not.
So better off share it.
Both of them will, my lord.
Only thing she has to
Survive.
disclose how much is the pension, etc. Then it will be again difficult for me to. That pension, how much is the pension? How much will be that? My share, how much will be?
You
there?
got the pension today also in the morning, na?
No, no, I have.
You just say.
No, today in the morning I called of her mobile phone, my lord. I called her, my lord.
She got her pension.
Whether she is living, if it has to be given to the first wife exclusively, because law is that like that. So I say, about the negatives.
Yeah. Then what happened?
She told me that only I am surviving by this pension only.
But she has a son.
Only along with the son also, my lord.
What is the
class
age?
7,
Huh?
class 7. He's in class 7.
And that your husband
Yes.
was working, divorced him in 84.
84.
No, not.
84. There is no communication after the expiry. After the death of my husband, my lord, she has submitted
So
representation.
16 years
No, but not 30 years.
and another 23 years.
Yes.
16 years and 23 years is what? And she has been getting the pension from 2008.
Salary, etc.
From 2008 you are getting?
No, 2014. Expired in 2014. My husband expired 2014.
And when did you marry?
Married 2008. In papers also, my name is there as a nominee. Pension papers. They have annexed there.
So if you can't part it, 50?
50-50. Yes, my lord. Your lordship can direct.
So you both of you agree. I can't give that order. If you agree, only I can do it. Because for me to pass an order would be difficult. I have to hold it. It is a nullity.
They both have been started.
Lordship, in that case, from the beginning. 50-50 from the beginning. 2014.
Why will she must have spent the money? How
In
can
that
she
case, he has
survive?
already enjoyed it, a husband for this many years with the pension. His
How will he survive? Tell me, how will she? How much pension does he get?
6,000-7,000 maybe. This
No,
year.
it is not 6. This is, it is quite high.
No, not high.
He was senior.
Yes,
Ananko.
13,000 maybe, madam.
In the year 2013, the petitioner, the husband of the petitioner was getting 6,150. Therefore,
That will be increased now.
Increase.
With the 7K
Hardly
commission kicking in. it will
hardly
increase.
12, 13 maybe.
Huh?
13, 14 maybe, madam.
So you say 50%.
50.
Enter into an agreement. Then he will withdraw. That is the only way out.
Yes, madam.
Else you have no case. Forget about filing affidavit. Affidavit, the moment you file, you're finished.
Revert.
At the request of the parties, matter stands adjourned for 2 weeks. Now, at the request of the parties, to the effect that they are trying for an amicable solution, matter stands adjourned for 2 weeks. List the matter again on 26th of June 2023. You think about it.
Yes, madam. I prepared that.
Only one crime, madam. Revenue department is the party. Let the name of SC revenue be shown in the first list, madam. Thank you.
This one,
Because he belongs to revenue officer.
the registry shall show the name of SC revenue.
Madam, I'm so obliged.
Hello, 52.
You have filed an additional affidavit, my lord. Para 2, my lord.
None appears on behalf of the petitioner on call. Mr. Tina appears on behalf of behalf of the respondent number 1, 2, 1 and 2.
1, 2.
And 3. 3 also.
Yes, 1.6.
Mr.
I am for respondent 4, my lord.
Mr. J. Patwari appears for respondent number 4. The instant writ petition was filed by the petitioner. Challenging the decision of the respondent authorities. In rejecting the technical bid of the petitioner. On the ground that the scanned technical documents were not attested by the bidder. That is the petition. It appears on record that this court, by an order dated 11/6/2021, had issued notice
on 9.
Observe that as the interim order would be, the interim order sought for would be considered on 12/7/2021. Till consideration of the said interim order, the petitioner was entitled to some ad interim protection and accordingly directed status quo to be maintained as on 11/6/2021 as regards the execution of the work in respect of, inverted comma, construction of sluice gate at Pandunath Mandir area to check backflow of river Brahmaputra, inverted comma, under the Guwahati East Water Resource Division till 12/7/2021. It further appears that the said interim order was continued from time to time. Till 4/1/2022. When this court fixed the matter for passing orders after 4 weeks. Thereupon, the matter was listed before this court on 30/5/2023. On which date the learned senior counsel appearing on behalf of the respondent number 4 drew the attention of this court to the fact that as on today, that the petitioner has suppressed material facts in the writ petition by not disclosing that on 6/6/2021, the EMD was received by the petitioner and the writ petition was filed on 8/6/2021. It was further submitted that by an order dated 13/5/2022, the Water Resource Department of the Government of Assam had also blacklisted the petitioner in view of withdrawing 2% of the earnest money of rupees 9,65,000 in respect of some other work which as per the said department was illegal. It was therefore a submission made on 30/5/2023 by the learned senior counsel appearing on behalf of the respondent number 4 as to the effect that this court should not further entertain the writ petition at the behest of a person who, as of now, cannot be an eligible tenderer in view of the earnest money deposit having been returned to him. And further, as the petitioner have been blacklisted by the department, which still by an order dated 13/5/2022, which still holds the field. Next. In view of the said submission, this court therefore granted an opportunity to the petitioner, to the counsel who represented the petitioner, to take instructions into the matter, more particularly in respect to those documents which were placed by the respondent number 4 and kept on record as marked with the letter X and Y. This court accordingly fixed the matter on 31/5/2023. However, on 31/5/2023, none appeared on behalf of the petitioner. However, during the course of the hearing, a question arose taking into account the bid validity period as to whether the other eligible tenderers would be inclined to extend the bid validity. The learned counsel appearing on behalf of the respondent number 4 submitted that they are inclined to extend the bid validity. However, taking the importance of the said aspect, this court directed the matter to be listed on 1/6/2023, thereby giving an opportunity to the respondent number 4 to place the said aspect by way of an affidavit. Next. When the matter was listed on 1/6/2023, the respondent number 4 had submitted an affidavit However, as pointed out by Mr. D. Nath, the learned counsel appearing, senior government advocate appearing for the respondent number 1, 2, and 3, the said affidavit was not clear. And was ambiguous. Was not clear. Was not clear. Was ambiguous. Not clear to know, was ambiguous. Under such circumstances, this court further permitted the learned counsel appearing on behalf of the respondent number 4 to file an additional affidavit which have been filed today. It appears from the said affidavit at paragraph number 2. That the respondent number 4 was agreeable to execute the work in question as per its bid submitted pursuant to the NIT dated 30/1/2021. In the backdrop of the above prelude, let this court therefore take into account as to whether the instant writ petition, whether the powers of judicial review needs to be exercised in the present facts of the case. The reason why the petitioner's technical bid was rejected can be seen from Annexure 9 to the writ petition, wherein it is shown that the scanned technical documents were not attested by the bidder. It is further apparent from a perusal of the affidavit in opposition filed by the respondent number 2 on 19/7/2021. Wherein it was stated that not only the petitioner did not submit attested copies, attested scanned copies, did not submit the attested scanned technical documents, but also the bid so submitted was in contrary to clauses 17 and 18 of the instruction to the bidders, bracket ITB. It was mentioned that it was the requirement that the tender documents, that the hard copy so submitted and the soft copy so uploaded should be a replica of each other. However, in the online technical bid submitted by the petitioner, it had 88 pages, that too without any pagination. Whereas the hard copy of the technical bid submitted by the petitioner contains 60 pages, and the same were paginated from 1 to 57, apart from 2 pages of index and 1 copy of the challan. It is therefore the case of the petitioner respondents in the Water Resource Department that not only the scanned technical bit was uploaded, but the hard copy so submitted and the online and the soft copy so uploaded differed. The learned counsel, appearing on behalf of the respondent, Mr. D.K. Nath, further drew the attention of this court to the judgment of the Supreme Court in the case of in the case of Tata Motors Limited versus Brihan Mumbai Electric Supply and Transport Undertaking (BEST) close, and others, reported in 2023 SCC Online SC 671, and drew the attention of this court to paragraph 52, 53, and 54. Wherein the Supreme Court had observed that a REIT court should refrain itself from imposing its decision over the decision of the employer as to whether or not they to accept the bid of the tenderer unless something very gross or palpable is pointed out. It was further observed by the Supreme Court in the said judgment that to set it not the entire tender process at a stage when the contract is well underway would not be in public interest. Inasmuch as initiating a fresh tender process at this stage may consume a lot of time and also loss to the public exchequer to the tune of the crores of rupees. Paragraph 52, 53, and 54 of the said judgment is quoted here in below. The learned counsel for the respondent Water Resource Department further submitted that this construction, that the contract in question, which is the construction of a sluice gate at Pandunath Mandir area to check the backflow of the river Brahmaputra, is a very important contract requiring urgent execution. Urgent execution in public interest. And as such, in view of the above law, and as such, the order of status quo so passed have greatly delayed the execution of the work. This court, therefore, taking into account that the rejection of the bid of the petitioner on the ground that the scanned copy of the attached documents, that the scanned technical bid did not contain attestation. And further, as the hard copy as well as the soft copy differed, as already mentioned, is of the opinion, therefore, that the exercise of the jurisdiction under Article 2 to 6 for judicial review cannot be exercised in the instant case. Accordingly, this court, therefore, dismisses the instant writ petition. The respondents in the Water Resource Department shall bring the said tender to its logical conclusion at the earliest. I passed this long order, there is a reason.
Correct.
Because tomorrow he may again come up and say, look here, my lawyer did not inform me.
Correct. Correct. The order status quo is negative.
Interim orders, if any, stands vacant. The interim order of status quo. Now, in view of the dismissal of the writ petition, the interim order of status quo stands vacant.
The records are with me. I'll keep.
Item 22.
Lordship, the amount has been sanctioned here. The area salary amount, Your Lordship.
You got it?
No, the ceiling for the said amount is yet to be approved. So it will take another, from my experience, 2-3 months. Matter will keep pending.
Oh, this will sanction has
It's
been
already
granted.
Thereafter, they have to move for selling.
Huh?
They have to again move for selling
Ceiling for what?
for this amount lordship.
So they will pay. It's okay. We dispose it of. Now it has been sanctioned, it will be disbursed within 2 months.
Lordship.
Why should we keep this? We need not monitor it, have a continuing mandamus on these matters. Yes, heard Mr. A. Dekar, the learned counsel, appearing on behalf of the petitioner, Ms. D. Musairi. Madam,
Lordship.
you remember that matter I
Lordship,
disposed of?
Lordship, item 54.
The reason why I brought it again is,
Lordship.
at the time while I was dictating as on 3/3/2011, if you remember.
Lordship, Lordship,
While dictating, everything is complete.
Lordship.
Then I said that it will be going back to to 2006.
2000, yes, your Lordship.
So it was mentioned that no, it will be 3011.
3011.
If it is 3011, then 1811, that document is there.
Lordship, it's there.
Then how can I give it?
Lordship, Lordship, Lordship,
Because while dictating, you are in a flow, so you don't get that point.
Lordship, Lordship,
So I brought it.
Lordship.
Heard Mr. A. Deka, the learned counsel, appearing on behalf of the petitioner. Mr. D. Musairi, the learned standing counsel, appears on behalf of the Elementary and Secondary Education Department. The case of the petitioner herein was as regards the herein pertain to non-receipt of the monthly salary from 15/2/2006 to 23/4/2008, which amounts to rupees 1,86,043. It appears from the record that pursuant to various orders passed by this court, today the learned counsel appearing on behalf of the Elementary as well as the Secondary Education Department of the Government of Assam have placed on record that the Secretary to the Government of Assam Department of School Education have already written a letter communication to the Accountant General AE Assam, thereby conveying the sanction of the Governor of Assam of an amount of rupees 1,86,043 for payment of the area salary with effect from 15/2/2006 to 23/4/2008 in respect to the petitioner. Taking into account that the said sanction has already been granted and it is only a formality for the purpose of disbursement of the said amount to the petitioner, this court therefore disposes of the instant writ petition, thereby directing the respondent number how can I direct to the, you have not made the Accountant General party. Thereby directing the respondents in the elementary as well as the secondary education department to ensure that the disbursal of the said amount is made, that the said amount is disbursed to the petitioner. This court further directs and the same is done, disbursal of the is disbursed to the petitioner, and the same be done within a period of 2 months from the date of the instant order. From the date a certified copy is served upon the respondent number, which one?
Lordship, it will be 3, Director of Secondary.
Respondent number 3. The instructions were submitted by Ms. D. Musairi, the learned counsel appearing on behalf of the Elementary and Secondary Education Department, is kept on record and marked with the letter X.
Obliged.
Obliged.
29.
Yes, Mr. Sharma.
Lordship, here an instruction has been issued by the director to the district elementary education officer.
That is the worst thing you do. After these matters are here, why you keep on asking?
Lordship, to comply with the order of this honorable court for releasing the salary, arrear salary. That instruction is there, Lordship.
Directing to DDO
DO, district elementary education officer.
for disbursing it. Sanction or
Not to comply with the order. Because
comply with what order?
for making payment, releasing the salary.
Then
And subsequent development from district elementary education officer is yet to be received, Lordship. Perhaps it will be process and released.
pendency of the repetition shall not be a bar to authorities to release the areas and current salary pay. No, I don't understand. What do you mean by that? You are only forwarding a copy.
Lordship, that
You have not asked them to pay, make the payment.
instruction, Lordship.
And how can this payment be made? This is an area salary.
Lordship.
How can without a sanction be given?
Lordship, that because that they will forward the proposal now to the director.
So it's a long process.
Director will record sanction.
Ah, long process. Then
Lordship. Then thereafter the director will forward it to the government for
very well.
approval.
So nothing.
It will take some time. Otherwise,
This
that-
was done on 5th of April. When I asked you on 3rd of April,
3rd
you
of
have done it on 5th of April. Then what happened?
Subsequent year to this letter has been issued.
But
And
we
now
are in the month of June.
Lordship.
What has happened in the meantime?
Subsequent development is yet to be received, Lordship, from the DEO. Lordship will fix the matter after 1 month, Lordship. By the time perhaps the matter will be resolved.
No, it won't. You asked what happened after 5-4.
Lordship.
We'll take it up after some time.
Today, Lordship?
Yes. Today is my last date in this bench.
Lordship.
Finish.
36.
Yes, who appears for? Respondent number 1, 2, and 3. Who is respondent number 1, 2, and 3? Any instructions?
No, Malak, no instructions.
Why?
And, in fact, I have written to the department,
Ah,
but till now I have not received any instruction. I'm praying for some time, Malak.
very well. When?
At least 1 week, Malak.
Family pension.
There is some deduction in the family pension, and it was not given in the extended pay scale, my lord. He is otherwise getting pension, my lord, but there was some deduction, an amount of rupees 43,718 rupees.
Then
Basically, he is claiming.
I gave you enough time.
Yes, my lord.
In fact, this matter did not reach on the last
Yes,
occasion.
my lord. It was on fixed on 8/5/2023.
Then why nothing has happened? Hello. Heard Mr. N.J. Khatonia, the Learned Counsel, appearing on behalf of the respondent number 1, 2, and 3, who submits that the instruction as sought for by the order dated 24/3/2023 have not yet been received, have not been received. He, however, submits that he may obtain the instructions within 15 days from today. Taking into account the same, let the matter be listed on 28th of June 2023. The Learned Counsel shall ensure obtaining the instructions in terms with the order dated 24/3/2023.
Oblige, Lord.
40.
For the respondent, huh? 1 to 3.
May I take it? It's a non-payment of arrears query. Last occasion.
Sorry, on behalf of yourself, applies on the returnable date why the petitioner has not been paid the area salary for the period from so and so to so and so. Shall apply if the petitioner is entitled to when the amount will be paid.
Lordship, I pray for some time, Lordship, I have not received in September.
Means 15-20 minutes.
No.
Then time depends on that. Days, months.
Lordship, 2 weeks.
Yes.
Lordship, similar matter was fixed by this court on 16th of June. The matter come on same day.
When?
16/6.
This matter?
Similar.
Okay, get you into it. Mr. B. A. Buzar Burwa, the learned counsel for the petitioner. Mr. B. Chaudhary, the learned counsel appearing on behalf of the respondent numbers 4 and 6 submits that he has not received any instruction pursuant to the order dated 3/4/2023. Let this matter be again listed on 16/6/2026. 16? Why? 16/6/2026, 23. The learned counsel for the BTC shall ensure that he receives the instructions in terms with the order dated 3/4/2023.
41 and 42.
Yes. Oh.
Lordship, petitioner has been reinstated, Lordship.
Well, just both.
Yes, both.
See? Your thing is done.
Lordship.
The long motion order helped you. Okay. Both you are appearing?
Close.
Heard Mr. To hold 2807/2023. Heard Mr. R. Ali, the learned counsel for the petitioner. Mr. D. Upamanyu appears on behalf of the Higher Education Department.
Yes, Lordship.
The instant writ petition was filed challenging the continuation of the suspension order dated
6/1/2023.
6/1/2023 by the Director of Higher Education. The learned counsel appearing on behalf of the Higher Education Department places on record that on 30/5/2023, the petitioner was reinstated in his service with immediate effect, subject to the outcome of the final report of the charge sheet against the Borpeta PS case number 1058/2022, as well as the report of the concerned inquiry committee. Taking into account that the petitioner have been reinstated, no further cause of action survives in the instant writ petition, for which the instant petition stands closed as infructuous. The said document so placed by Mr. D. Upamanyu, the learned counsel for the respondent number 1 and 2, is kept on record and marked with the letter X. Ikonoto Ike, date is 1/1/6.
Same date. Subsequent date same.
The date is same, but here is 1/6, and the other 802
35.
807 it is 35. 27750 it is 1/6. Okay.
Highly advised.
54.
Mr. Doctor, tell me, how are you entitled to if it is on 30/11/2021 to 2011?
What, the scale? Yes, my lord, this circular, my lord, is.
You said
My lord.
if your entitlement is only on 30/11/2011, how are you entitled to? By that time, 18/11/2011 holds the field.
No, my lord, that is with regard to upgradation of the post. This is with regard to the scale, my lord. That's the reason, my lord.
No, 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 no,
Yes,
no.
my lord. These are two different notifications, my lord.
No, no, no.
Lordship, see, my lord, here, in the other case also, my lord, the order which I have annexed, my lord, similar case, my lord. Where,
I'm
my
not
lord-
on this similar case. I'm only on this thing.
Yes, my lord.
On 7th of, you say that the benefit of the terms in terms with the notification dated 7th of February 1995,
My lord.
you are entitled
My
to.
lord.
I inquired with them
My lord.
and they said to me
My lord.
that they have no other document
Yes.
because your specific submission is the amalgamation happened in 2006.
Yes.
And as such, you became a secondary school teacher
Yes.
for which you are entitled to.
Yes.
Fantastic.
Yes.
But your entitlement only comes on 30/11/2011.
Yes, that-
By the time 18/11/2011 comes in.
That notification, my lord, is with regard to, my lord, upgradation of the post, if I'm not wrong, my lord. Because that is the reason why it was
No,
rejected.
no, here it said after careful consideration of violence, the government have decided henceforth no proposal for upgradation of teachers having degree qualification and appointed in intermediate scale or pay be submitted for consideration by the government. Similarly, proposals of upgradation of grade 2 PG teachers should not be submitted to the government.
Exactly,
These supersedes all other office memorandum.
Exactly. I'm not asking for upgradation. This is the ground on which my application was rejected.
Hmm.
Here, petition was rejected. Thereafter, my lord, then, my lord, I said, my lord, if it's a rejection, my lord, I can be granted the scale. A similar order was passed, like your lordship is saying, is a concession order. My lord, that's a fact, my lord. That's the reason, my lord, I alternatively, my lord, I relied upon, my lord. That was the argument I placed, my lord. Alternatively, I placed this reliance upon, my lord, 7th of February 1995 notification.
Hmm.
Now, my lord, they then produced this letter, my lord, saying that there was another notification of 1993 and followed by one of 1995.
Hmm.
This, my lord, here with regard to my upgradation, my lord, upgraded scale, my lord, as per, my lord, FR22, my lord.
Hmm.
So this is not, my lord, equivalent to, my lord, upgradation of the post, my lord. They had rejected my claim on the basis of the 2011 notification, saying that I'm not entitled to upgradation of the post. Then I said, my lord, if not upgradation of the post, at least grant me the scale. That is the reason, my lord, this I'm holding, my lord. My case was alternative, my lord, that 7th of February notification will come.
Which document you are saying 7/2/2005 is where?
My lord, 80, Annexure 8, my lord, 1995.
Page?
Page, my lord, 27, my lord, Annexure 8.
27.
Yes.
In pursuance to so and so FET so and so 94 in respect of upgraded pay scale of so and so in graduate for so and so. Fixation of pay in upgraded graduate scale will be regulated under FR 21 of the fundamental rule.
And accordingly, my lord,
This order was passed on consensus.
consensus, my lord, but in this order, my lord, that's why, my lord, I placed this notification of 1995, where there's a provision for, my lord, giving them the scale, my lord, under, my lord, FR 22(1). Here also, my lord, in the other case also, my lord, it was contended, my lord, this upgradation of post is not permissible anymore. Then, my lord, this consensus was given. But here I'm trying to rely upon this two notifications, my lord, and on the instruction that your lord.
Wait. Now, then if that is so, how do you say about if that was the submission and then the matter came up on this date, when you say the court by this order dated sought for instruction as to whether the petitioner would be entitled to the benefit in terms with the notification. The learned counsel had placed on record a set of instruction issued by wherein reference was made to the office memorandum dated 30/12/2019, wherein stipulated that the existing post of Imam in intermediate per month with graduate incumbent or provincialized higher secondary schools in the post of year to be entitled to graduate scale per month from the date of issue of the mentioned that the government notification dated 22 was applicable in respect of those existing intermediate working in the school under the secondary at that point of time. However, who was working in the element at that relevant point of time, it is only in one the petitioner became a part of the secondary education department. The petitioner would be entitled to the benefit dated given to later on. No, this instruction which was given on this date, where is that instruction?
2523, madam.
An instruction given. Yes. On 25.
There, madam, this 2011 notification is not nowhere mentioned.
Here the instruction says, moreover, here you have a copy of that instruction?
Yes, madam.
With reference to the act, I wanted to state the necessary instructions in manual submitted to the senior standing counsel on demand. Copy along with student. Moreover, in continuation to the above reports, the following additional information. School, namely so-and-so, was amalgamated as in the year 2006. Subsequently, the petitioner came under the jurisdiction of the secondary after amalgamation in the year 2006. The government in the education department writes so-and-so upgraded the existing post of assistant teachers in the intermediate scale of pay of so-and-so with graduate incumbents of provincial and higher secondary to the post of assistant teachers in graduate scale. The said notification dated 30 was applicable in respect of those existing intermediate teachers working in the secondary school at that point of time. But in the instant case, the petitioner was working in the elementary and his service was come under the after the amalgamation. Therefore, the claim of the petitioner for graduates in the strength of demand, dated demand, and subsequent dated demand cannot be considered and liable. No, understood. But then why did you say that your entitlement will be from 30/11/2011?
Otherwise, earlier a person was holding that post, so that post fell vacant. So initially, I was seeking upgradation to that post. But then, because of this bar, of this notification came in, so they rejected my claim. Now, on that particular day, your lordship had pointed out that since this came on 18/11, November 2011, so therefore you're not entitled. Then I alternatively said, that since I am trying to, my case is that I should be given the scale in terms of the 1995 notification. Then, they produced this notification. So this notification nowhere refers to the 2011 notification. This is on total different line altogether. And that's why my prayer, like in the other case, I'm only seeking that I should be given that upgraded scale of pay, not the post. And anyway, I cannot get the post anyway.
But how can you? This 18/11 was on.
This was with regard to the upgradation of post. The logic was, my lord, the requirement is by direct. This post are to fill out direct recruitment method. Therefore, my lord, the upgradation was not possible. Because under the new rules, my lord, under the 2003 rules, my lord, this posts are to be filled up by direct recruitment. And that is the reason they could not have promoted me, my lord, or upgraded me.
So you mean to say the 1811 relates to upgradation of the post? Now you are on upgradation of the pay.
That's in terms of FY22, whatever I get, my lord, he will put this in that particular slab, my lord, and give me the whatever I'm eligible to. That is the only limited prayer now at this stage.
Apart from this consensus order, was there any other order passed
No, my
by coordinate benches?
No, my lord, I don't know. To my knowledge, I don't know. But this person has been given the benefits. The person in whose favor this order was passed by consensus order, he has been given the benefit that's happened to.
That is obviously it's a consensus order.
But then, my lord, therefore, my lord, in fact, Lordship had pointed out this aspect, you know, that in the 2018-11 order, my lord, where is your scope for getting this, my lord, because of your date of retirement or date of claim, my lord? That's the reason, my lord, I said, my lord, I am entitled to at least the scale of pay in terms of 1995 notification. And accordingly, these instructions were they were produced, my lord, on the 2nd of February to May, man. In this instruction, where there is no reference of this 2011 notification. Here, my lord, they were trying to say, my lord, this is a scheme for, my lord, those in the secondary department. I am from outsider. I'm an outsider.
So your rejection was made on the basis that this cannot be, your post
Yes,
cannot be upgraded.
11 notification, my lord. Though I has not served a copy, my lord, but this is the reason, my lord. 1811-2011. Second but last paragraph before the order, my lord. Page 25.
Where is that order?
Page 25, Annexure 7.
After careful, it is
Before that, my lord, the proposal for
post from intermediate scale cannot be considered.
proposal, my lord. The proposal.
So here the question before them was as regards upgradation of post.
Because initially I sought upgradation, my lord. When I came for the first time, I sought upgradation of the post. So this honorable court directed that my case be considered. Accordingly, they considered and said, my lord, because of 2018 11 notification, upgradation is no longer permissible. Whereas in the other similar case, my lord, which my lord had referred to, my lord, there the contention was, my lord. Well, in fact, there is another order. Yes, my lord. Today morning, my lord, I've been going to an order, my lord. Yes, my lord. Take out, my lord. There also, my lord, similar order has been passed.
Consensus.
I'm just going to have a look at that.
Consensus, no
It has been
problem.
forwarded to me, my lord. There is consensus. Something like that.
But why you would not be entitled for pay, upgradation of pay till he retires if it is the case of 2006?
My lord, since already their teacher was there, my lord, and I have been discharging his responsibilities after he retired, my lord. So
No,
I
no,
was,
that is one aspect
that
of the
is one
matter. I'm not on that.
my lord.
You were rejected on this ground if this particular instruction is looked into,
My
which you have seen it,
My lord.
on the ground that you were in elementary school.
My lord.
But in the case of the petitioner was working under elementary education department and his service came under the secondary department after amalgamation of his serving
Exactly,
school with Fakhruddin Ali Ahmed in the year 2006.
my
So your therefore submission is that from 2006, you came within the ambit of a secondary education. So by that, being in secondary education, you are entitled to. But your entitlement will spring only on 30/11/2011. That becomes the thing which
Well,
this
the
court is.
difficulty maybe because prior to that, my lord, perhaps against one post, my lord, two payments cannot, people cannot be paid.
No, that is okay. So, no, but were you not brought by way of an amalgamation to that
Yes.
within the fold of the Department of the Secondary Education?
That is true.
If you were bald, why you get it?
Because my earlier claim was with regard to upgradation after he retired. The original incumbent of that post, my lord.
No, there it's okay because there against that post you are asking.
Yes, yes.
But if your case is, therefore, this court had the difficulty in signing that order because of that person. That if that is so, your claim is that there is no notification by which the 7/2/1995 notification has been taken out, which they have admitted.
Yes.
So then why not you are entitled from 2006?
Well, my perhaps for the.
And if you put it on 30/11,
My lord.
then
Because from that day, basically I was doing the response, taking over the charge of doing the service of a higher post, teaching in higher schools after income and retired. So therefore, as a matter of fact, I was discharging the duties of that graduate teacher only after this person retired. I mean, I might have been doing some classes here and there, that may be a different issue. But then after he retired, since there was no other person there, so I was discharging his responsibility for all technical purposes. I was discharging the responsibility of the graduate teacher. And therefore, my lord, I was claiming
so
that.
are you okay? Is your case that on maintaining that getting a pay equivalent to the work you are doing?
My lord, to a certain extent, yes, sir. Because my lord, here I was, my lord, after
Madam, you put it on affidavit test. Because why I'm saying is there are two aspects. The petition, they have mentioned the date at 30/3/2011. Now he says that the date to be 30/11/2011. This, I think you need to put it on affidavit as regards the queries so made as to whether he will be entitled on. That is better off. And from when? Heard Mr. M. Dr. the Learned Counsel appearing on behalf of the petitioner. Ms. D. Musairi appears on behalf of the respondent. Secondary respondent
1, 2, and 3, your lord.
1, 2, and 3. Finance has no role.
Finance is not a party respondent, he has only implemented the treasury officer.
Huh? Treasury is unnecessarily made a party. Finance should have been. Because this order of 7/2/1995 springs because of the finance notification.
I have noticed. I have noticed.
Mr. R. Barbuzari appears for the respondent number 4. Taking into account that Mr. R. Barbuzari is also the standing counsel of the finance department, and the entire controversy arises in view of the as regards the interpretation to the notification dated 7/2/1995, which is based upon a message by the Finance Establishment A Department. This court is of the opinion that an affidavit from the Finance Department of the Government of Assam would be necessary as regards the said notification dated 7/2/1995, and as to whether any further notifications have been issued by the Finance Department in that regard. This court further, taking into account that there was a typographical error in paragraph number
8, madam.
8.
Paragraph number 8 and paragraph number 21, to the effect that the post of the Arabic teacher fell vacant on 30/3/2011 should have been 30/11/2011 as submitted by the learned counsel for the petitioner. Further directs the Director of Secondary Education to file an affidavit in the matter as regards whether the petitioner herein would be entitled to in terms with the notification dated 7/2/2005. 95 or 5? 1995. 7/2/1995. And would be entitled to the graduate scale of pay in terms with the notification dated 7/2/1995. The said affidavit, taking into account that the petition pertains to the year 2015 and the petitioner has long retired, let the affidavits be filed by 23rd of June without fail. List the matter again on 28th of June.
Lordship has directed the finance department to file affidavit in terms of this
Hmm.
notification. But
And as to whether any other notifications have been issued pursuant that.
no, Lordship, there is a distinction. This notification has been issued by the education department.
Understood. That is one type it has been stated as per the finance department's message.
That's what I was about to submit, Lordship. I may be allowed to bring on record this message because
You know this notification. 100% when a notification is issued, you are informed that we have done this. So you do whatever it is. What is the, because this was done at your behest.
Therefore, if my lord precisely direct my lord instead of this notification, the message my lord on the basis of which, then I would be in a better
তাহলে
position.
উপরে এই লাইনটা থেকে দিব, হ্যাঁ? And yeah, because on the interpretation of Iman Kilnikina, the finance department in this affidavit shall also indicate on what message the said notification dated 7/2/1995 was issued.
The other day, your lordship directed to me to take trustee service, my lord. Accordingly, I have taken and filed an affidavit also to that effect, my lord. But the phone number 3 just appeared.
You have taken justice service?
Yes, my lord. I have filed the affidavit also on 16/5/2000.
We dispose it of. Because there is a direction by the director also. Then also they have not done it.
Right.
So it's required. Third, Mr. H. Rahman, the learned counsel appearing on behalf of the petitioner, Mrs. S. Burwa, appears on behalf of the respondent number 1, 2, and 4. This court by an order dated 28/4/2023 had issued notice making it returnable today. This court further directed that the service upon the respondent number 3 be effected by way of registered post with AD as well as through usual process. This court further granted the liberty to the petitioner to take service upon the respondent number 3 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. It appears from the office notes that the notice upon the respondent number 3 was issued on notice by registered post was issued on 4/5/2023. It further appears from the track consignment that the said notice was duly delivered upon the respondent number 3 on 15/3/5/2023. And in that regard, there is an order of the Lozima Court that the service upon the respondent number 3 was duly effected by way of registered post on 15/5/2023. Apart from the above, it is also apparent that the petitioner also took steps by way of Dasti and served the notice on 8/5/2023, which is evidence from the endorsement so made in Annexure 14. The same is further evidence from the affidavit so filed by the petitioner on 16th of May 2023 that the service was duly effected upon the respondent number 3. However, the respondent number 3 have chosen not to appear before this court today. In the backdrop of the above, this court takes up the instant writ petition for disposal It appears from the records that the petitioner herein was issued a show cause on 14/2/2017 by the chairman of the respondent number 3. Pursuant thereto, on 15/2/2017, the petitioner submitted the reply to the said show cause. It further appears from Annexure 6 to the writ petition that the respondent number 3 for the reasons assigned therein, suspended the petitioner from the services with effect from 20/2/2017. Thereupon, it is the case of the petitioner that there was no further proceedings initiated, and by an order dated 24/3/2020, on the basis of the decision taken by the board of the respondent number 3, the petitioner was discharged from the post of accountant with immediate effect for embezzlement of the board's own fund and destruction of board's property. The petitioner thereupon, on 30/7/2020, filed an appeal before the Principal Secretary, Urban Development Department, the Joint Secretary to the Government of Assam, Assam Urban Development Department, issued a communication on 26/2/2021 to the Executive Officer of the respondent number 3. Thereby requesting for reinstatement of the petitioner as per section 50 of the Assam Municipal Act 1956. Subsequent thereto, by another communication issued on 26/10/2021 to the Executive Officer of the respondent number 3, issued by the Director of Municipal Administration, the Executive Officer of the respondent number 3 was requested to take necessary action as per the government order mentioned dated 26/2/2021 regarding the matter of reinstatement of the petitioner along with another to the original post for the interest of Amguri Municipal Board. It is relevant to take note of that in the said order, there is a reference to a communication issued by the Executive Officer of Amguri Municipal Board dated 27/1/2021 that reinstatement of the 2 employees are necessary for the interest of functioning of the board, and the same will also ensure recovery of the lost assets of the board as per the Assam Municipal Act 1956. This court, upon perusal of the materials on record and upon hearing the learned counsels, finds it relevant to take note of that on one hand, the chairman of the respondent number 3 had by the communication dated 14/2/2017 asked the petitioner to show cause as to why departmental disciplinary action should not be initiated against the petitioner, to which the petitioner had duly submitted its reply on 15/2/2017. Why departmental disciplinary action should not be taken against the petitioner, and why the petitioner should not be suspended from the job for the reasons mentioned in the said show cause. The petitioner replied to the same on 15/2/2017. By the order dated 20/2/2017, the respondent number 3 only took the decision to suspend the petitioner with effect from 20/2/2017. With a further decision that the respondent number 3 shall provide the petitioner the salary and allowance as per the government rules during the suspension period. There is no materials on record which would show that there was any disciplinary acts, proceedings thereupon initiated against the petitioner. This aspect of the matter has also not been controverted by the respondent number 3 by appearing before this court in spite of service of notice. Be that as it may, by the order dated 24/3/2020, the petitioner herein was discharged from the post of accountant with immediate effect for embezzlement of the board's own fund and destruction of board's property. At this stage, this court finds it relevant to take note of that it is no longer a res intriga, that when an action is taken which has civil consequences, the principles of natural justice at least has to be followed. The show cause notice issued on 14/2/2017 nowhere speaks about what penalties are to be imposed. It merely has been issued as to why departmental proceedings should not be initiated against the petitioner. Therefore, the said show cause notice under no circumstances can be taken into account as a show cause notice issued for the purpose of passing the order dated 24/3/2020. It further appears that pursuant to the order dated 26/2/2021 issued by the Joint Secretary to the Government of Assam Urban Development Department, the reference of which can be seen in the part. The Director of Municipal Administration have also requested the Executive Officer Amguri Municipal Board to take necessary action for reinstatement of the petitioner along with another to their original post for the interest of Amguri Municipal Board. It is relevant to take note of that the said order dated 26/10/2021 was issued, taking note of the communication issued by the Executive Officer of the respondent number 3 dated 27/1/2021, wherein also it was stated that the reinstatement of the 2 employees, including of which the petitioner is one of them, are necessary for the interest of proper functioning of the board, and the same would also ensure recovery of the lost assets of the board as per the Assam Municipal Act 1956. In spite of the above, the petitioner was not reinstated. This court, taking note of that the actions of the respondent number 3 violates the very mandate of violates the principles of natural justice, which in effect renders the action of the respondent number 3 board to be arbitrary and unreasonable, and accordingly in violative of Article 14 of the Constitution, therefore sets aside the office order dated 24/3/2020, whereby the petitioner herein was discharged from the post of accountant with immediate effect for the reasons assigned therein. Accordingly, this court therefore directs the respondent number 3 to reinstate the petitioner with the above the instant petition stands disposed. Reinstate the petitioner upon a certified copy of the instant order being served upon the respondent number, upon the executive officer of the respondent number.
My views are maybe released by the time bound period. As they admitted this.
Which due?
My subsistence allowance and others. That is
Before concluding, this court further takes note of the submission of Mr. H. Rahman to the effect, the learned counsel for the petitioner, that the petitioner is entitled to various dues.
Yes.
This court is of the opinion that as the entitlement of the petitioner to the dues is subject to certain verification, as well as the question of recovery may be also, as well as certain recoveries to be made, as could be seen from the orders of the Director of Municipal Administration dated last date 27, 26. The last order, right? This court therefore directs the respondent authorities, respondent number 3, to take a decision on the matter within a period of 2 months from the date of reinstatement of the petition as directed herein.
Item 56.
There is an instruction, my lord, that of 2015, my lord. My lord, in 2015, when the matter was came for Lok Adalat, my lord, then one letter was sent to the registry, my lord, that consequent upon his aforesaid conviction under Rule 21 of Assam Service Pension Rule 1969, Mohammad Mokibul Islam was found guilty of misappropriation of government money and also causing pecuniary loss to the government. Accordingly, the necessary action was taken as per provisions of Assam Services Pension Rules 1964, and his provisional pension, which was granted earlier, was stopped, withdrawn. It is of 2015, now December 2015, my lord.
Understood, but
And
there
my
has
lord-
to be an order of the governor.
My lord, no other order recovered.
Now, there is no order by any commissioner, secretary, all these things.
No, my
Nobody,
No, my lord.
except
After
that, who has done that?
This is done by the director, my lord. This
Is the
is a letter
director
given by
empowered?
the director to the registry, my lord, only. After that, no communication, I think.
You
I
need
have
to
not
find out. Have they not found out anything?
They have
Because
not
without
found
that, you cannot take action under 21 without that.
My lord. I
I
have,
think you need to.
yes, my lord. I have already informed about that to my lord. I asked any notification about of Rule 21, my lord, but they have nothing. They have not pressed anything, my lord. Perhaps for 1 or 2 weeks, maybe allowed them. I think they will get the other documents further. If there is any communication afterwards, they will find this is now by December 2015 only, my lord.
Hello, give it to me.
Second paragraph.
You say accordingly necessary action was taken as per the provisions of the Assam so and so, and in his provisional which was granted earlier was stopped.
Stop.
So necessary action was taken. There has to be something,
Yes, my lord. I know, my lord. I have also asked them, but
because this is a letter to the register vigilance.
my lord.
So you must have definitely taken some action.
Yes, as per the last paragraph of this letter.
It will be there in your disciplinary proceedings or or anything else. Did you initiate any disciplinary proceeding? No.
My lord, I have some disciplinary proceeding. Made
You have not. No discipline.
disciplinary proceeding perhaps.
Lord, may have a look at the affidavit. It says the director first stopped the payment of pension, then processed everything. Lordship may come to page 5 of the affidavit of respondent.
No. Mr. Chakravarti, this needs to be clarified because they said that they have taken some action. Let us see what it is.
Now, my lord, if your lordship has gone through the instruction, paragraph 2, and the last part of page number 5 of the affidavit, it seems the director has taken the call.
No, if the director has taken it, let him come up. The director has taken it. Now the director has no business to take it.
Exactly, my lord.
My lord.
Lordship may have a look at paragraph, the page number 5.
May I read, madam?
Not necessary.
My lord, actually the representation given by the petitioner was also addressed to the director actually. So
I give you a representation. Then does it empower you?
it's a communication only, my lord.
Today I direct, let it be given to the director, deputy commissioner. Payment has to come from then the what do you call the government, the main department.
It's perhaps
And
a
I direct the
communication.
deputy commissioner, you submit the representation to the department, the representation to the deputy commissioner, and you then say that the deputy commissioner would have the power.
No, my lord, perhaps this is the communication perhaps, my lord. So further some instruction are there which perhaps they are not find out today only after their 2013 matter, my lord, they have not found it today.
Every order or instrument of the government of the state shall be expressed in the name of the governor and shall be signed either by the secretary, an additional secretary, a special secretary, a joint secretary, a deputy secretary, and another secretary, or such other officer as may be specifically empowered in that behalf, and such signature shall be deemed to be proper authentication of such honor. So
And perhaps this is a communication, something, some paper documents are proper documents are there, I think. In
therefore,
there.
I'm giving you an opportunity.
My lord, have they, my lord, they are not in a 2013 matter. So they have not found some. My
Then if you, there's nothing out there, this court can't say that he is not entitled to pension.
No, my lord. 2 weeks time may be allowed as the officers are also not there. So my lord, 2 weeks time may be allowed.
Not two, I'm giving you 3, but file an affidavit.
My lord.
Heard Mr. S. Chakraborty, the learned counsel appearing on behalf of the petitioner. Ms. M. Kutuki, the learned counsel appears on behalf of the Assam Animal and
Husbandry and Veterinary
Department. You are appearing?
My lord.
Mr. A. Hassan appears on behalf of
Accountant General.
the Accountant General AE Hassan. You are appearing for?
3. Response number 3.
Who is he?
Judicial Department. LR.
The Deborah appears for the respondent number 3. The issue involved in the instant repetition is on a very limited compass. The issue, therefore, is as to whether, without an order of the governor in the manner stipulated under the Assam Rules of Executive Business, more particularly Rule 12, can the respondent authorities stop the pension of the petitioner even though the petitioner have been convicted by the judgment and order of the Special Judge CBI Assam dated 29/12/2006 in special case number 43/2004. court, while hearing the matter on 1/6/2023, directed the learned counsel appearing on behalf of the Animal Husbandry and Veterinary Science Department,
Veterinary Department.
Veterinary of the Government of Assam, to obtain instructions as to whether any order was passed in terms with Rule 21 of the Assam Service Pension Rules 1969. The learned counsel for the said department have produced before this court a communication dated 11/12/2015 issued by the director of the said department to the Register General Vigilance Secretary, Guwahati High Court Legal Services Committee, stating inter alia that in view of the conviction of the petitioner upon being found guilty of misappropriation of government money and also causing pecuniary loss to the government, necessary action was taken as per the provisions of the rules of 1969, and accordingly the petitioner's provisional pension, which was granted earlier, was stopped or withdrawn. In the opinion of this court, the said document cannot be a substitute to a document instrument to be made in terms with Rule 21 of the rules of 1969. Consequently, this court, taking into account the difficulty expressed by the learned counsel for the Animal Husbandry and so department, that it being an old matter, grants 2 weeks time for filing of an affidavit by a responsible officer of the said department, stating inter alia as to whether there was any exercise of power in terms with Rule 21 of the rules of 1969 by an authority empowered to do so. List the matter again on when.
And my lord, whether that order was communicated to the petitioner.
Is it required?
My lord, if the order is not,
Mr. Chakravarti, kindly don't make that. That is not, that's not the mandate of the rules,
no, my lord,
that it has to be communicated.
if an order is passed and if it is not communicated, then the question will come whether it will have the effect.
It depends on the order to be passed. It is not an order. These are orders which are to be within the realm of the government. They will keep it. You will know on one day.
No,
You
my
may
lord.
be, you may be.
To my understanding, my lord, if the pension is withheld or withdrawn, then it gives a right to the person to file an appeal. So if that is a right, then I definitely need to know the order.
We should dismiss your petition on the ground of statutory appeal?
No, my lord.
Then?
If that order is passed.
No.
Till now, my lord, we do not know whether that order.
So the moment, are you saying that the moment the order comes to your notice, then you are going to file an appeal?
If that order is.
Please the matter again on 23rd of June 22nd of June 2023. The affidavit be filed by 21st of June.
If this matter is parted.
Not necessary. These matters don't require to be made. I have the best which I could do. The instructions so placed on record is kept. This I won't give it. This is a draft on top.
What should make if this matter is parted?
Liberty is given to the petitioner to mention the matter.
Timing item 29.
Lordship.
Oh, that matter.
Lordship. My telephonic instruction is Lordship. Pursuant to that communication, Lordship, the salary of the petitioner has been released from March onward, Lordship. He's drawing his salary from March onward. And insofar as the arrear is concerned, because of the change of the financial year, the fresh proposal has been sought from the district elementary education officer, and the director will process further.
Yes, your name?
M.U. Mondal.
Mr. M.U. Mondal, the learned counsel appearing on behalf of appearing on behalf of the petitioner. Mr. P.N. Sharma appears on behalf of the Elementary Education Department. Pursuant to the instructions sought for by the order dated 3/4/2023, a communication was issued on 5/4/2023 by the Director of Elementary Education Assam to the District Elementary Education Officer Dhubri. Mr. P.N. Sharma, the learned counsel appearing on behalf of the Elementary Education Department, submits on instructions that the petitioner have been receiving the regular salary from the month of March 2023 onwards. As regards the area salary, in view of the lapsing in the budget, fresh proposal has to be submitted, which the district elementary
Education officer.
education officer is taking steps to do so. Let the matter be listed again on 26th of July 2023, on which date the learned counsel appearing on behalf of the Elementary Education Department shall apprise this court as to the status of the area salary proposal of the petitioner.
Right.
15 and 16 for admission.
Yes.
Yes, please, Your
Why
Worship.
both are same? What are you asking both?
My lord, the petitioner was appointed as chainman, my lord. As chainman,
Ah,
but he was appointed in the year 2013, my lord. But till date, his salary was not, the first salary was not. released. On the last occasion, my lord, the respondent were directed to file affidavit, my lord, on two queries, my lord.
yes, Revenue Department, what?
First, we will file our affidavit. But in person to the Lord,
You filed
11
affidavit?
Lordship.
Yes, settlement officer, what is he doing?
My lord, it was filed on 9, my lord. Lordship was directed to file on my lordship.
But the letter of
Third.
the revenue the same to the director. Now what is the status? Where is finance? Finance is not a party.
Finance is party.
Finance is party.
Yeah. They are the people who are creating all problems. What is your status after 2018? After 2018, what has happened?
Lordship, my lord, that in our affidavit we have stated. My lord,
I have stated that I have seen that. You kindly see this particular, the page 27, running page 27.
Lordship.
The government in the revenue department then directed the settlement officer
Lordship.
to resubmit the proposal to the DLR. The DLR versus so informed the government's approval was not obtained prior to filling up of the vacant post.
Lordship.
As recruitment process was not followed by the settlement officer, as per regulation, the matter of release of the first salary in respect to the petitioner is being examined in the revenue department. So this happened then. We are 5 years down the line. What has happened? Inform the government by that the word approved is so and so. Then
My lord, it was
Mr. Counsel,
Yes,
you are not filing a reply.
not yet.
If you don't file a reply, it will be disastrous for you. I hope you understand the scope and ambit of the affidavit. The affidavit says that you have been appointed illegally.
Yes, my lord.
You have read it. Don't you think that it is necessary to traverse? If you don't, it will be deemed to be accepted.
Then, my lord, I may be given time to file the reply.
Mr. Barbuzari, these appointments of chainmen being done on the first day, the settlement officer gives him the ROP. Eh, I put a query on the last occasion. This court further have raised another query to the effect as to whether without taking the SIU approval, which is required after 4/7/2005 in pursuance to the FRBM Act, how by an order dated 22/10/2013, the settlement officer Dhubri and Kokraja had appointed the petitioners as chairman in payment 1, thereby entitling the petitioners to pay in terms with the ROP rules of 2010.
it will settlement officer.
This court could also put a question as to whether there is a selection procedure for chairman.
Selection procedure, my lord, as per the, my lord, that
You do one thing, let him file affidavit. Your case is otherwise.
Here, my lord, difficulty is that my lord, finance is not a party. Otherwise, my lord, prima facie, my lord.
No. You are nay. Our proposal appears for finance department.
Oh, my lord, yes. Treasury officer.
only treasury officer. Even then, my lord, they did not, my lord.
No. Respond number 2 is finance.
Deputy commissioner, that is not the department.
No. Respond number 2 is finance.
Yes, actually, my lord, finance our- Where is it?
Treasury officer has been made because we are going to release the money.
I stand corrected, my lord. You skip it, my lord.
Heard Mr. So-and-so, the learned counsel, heard your name?
A. Rashid. A. Rashid.
A. Rashid, the learned counsel for the petitioner. Mr. J. Hendik appears on behalf of the revenue department. Mr. R. Bharpujari appears for the finance department. It appears on record that the affidavit, detailed affidavit in opposition has been filed by the revenue department. However, there is no affidavit, however, being filed by the finance department, and more particularly in respect to the queries so raised on 11/4/2023 by this court. Be that as it may, the learned counsel for the petitioner submits that he would like to file a reply to the same, for which 3 weeks' time is being granted.
Next date, my lord, I will, lordship will kindly allow me to put my submissions in as to whether it cannot be, my lord.
You have not filed affidavit.
My lord.
Yes, Mr. Bhuiyan,
My lord.
after 2000, the matter has been listed today.
My lord, I did mention.
Does anything survive?
Yes, my lord, matter relates to, my lord, arrear salary of the petitioner. No affidavit till date.
See, the affidavits are not given because of the fact that
Second time listed.
if this order, so and so has entered appearance and as such, 2 extra copies shall not be a bar to redress the grievances. Nothing in that. Yes, what do you say? Direct the respondents to extend the benefit of provincialization of the petitioner with effect from Iman and further be pleased to direct the authorities to pay him the area salary. What is this provincialization business?
My lord, I was entitled to the benefit with effect from 1/1/2013, but that has not been given.
Why?
Because, my lord,
Provincialized under what provision?
that the 2013 11 Act, my lord.
Okay, then you have been provincialized.
I have been provincialized, my lord. My service has been provincialized by way of an order.
Show me.
But my lord, may be pleased to find the order, my lord, is that page 34, my lord. Actually, my lord, this is a reinstatement order pursuant to the this honorable court's order, and this has been treated as all along the order of.
No, where is the provincialization
My
order?
lord, that provincialization, what has happened, my lord, during the time of my venture stage, I was removed by the management, my lord, and that removal was approved by the director of, my lord, secondary. And accordingly, my lord, the division bench of this honorable court has set aside my termination and directed for my reinstatement. And in the meantime, my lord, this school has been provincialized, my lord, during this intervening period of my removal and till the judgment is passed. Now, my lord, pursuant to this order passed by the division bench of this honorable court, this order at page 34 had been passed, giving my effect that I will entitle to the benefit of, my lord, this salary and other part.
Page?
Page 34, I am referring, my lord. The last line, my lord.
What does it say? In compliance
Yes,
to the
it
order
says that
dated
and
in
so and
pursuant
so,
to
we
and
are
so,
allowed
and
to-
is hereby released from the post of head mudare
My lord.
so and so, and is hereby allowed to hold the post of head mudare of Matado with immediate effect. Okay. Now, why is the whether your college have been whether you are there in this provincializations
Yes,
rules?
yes, because, my lord, as this honorable court has held, my lord, my removal was illegal. Therefore, there was a direction from the.
Your removal from where?
Removal from this institution itself, my lord, from the post of head mudaris.
No, but whether your order is there in the list of provincialization as per the 2011 notification under 10.4.
No, my lord, that notification they have not passed, but directly, my lord, this order has been issued at page.
No, understood. If that notification is not there, how is your service provincialized?
By way of this order, my lord, at page 34, my lord.
This order cannot be your provincialization order.
Yes, my lord, this is not an order of provincialization, but this is an order of my reinstatement.
Maybe, but where is the order of provincialization of your school?
That, my lord, there is an order of provincialization of the school. That
I think, don't you think it is necessary to bring on record? And another aspect which you need to find out as to if it is provincialized out there, your name not being included, wouldn't that come within the ambit of the educational tribunal?
No, my lord, because as I am not disputing with this
Yes, my lord.
provincialization, my lord.
Yes, my lord, because there has to be a 10-4 notification, my lord, under 2011 Act. And whether he will come under the schedule or not, my lord, that also has to be.
No, whether it comes into the schedule or not, wouldn't that come within the ambit of the educational tribunal?
Yes, my lord.
Unless if he's not there in the 10-4 notification, his entitlement to the salary from the government, you can't ask. Because you see that particular section 2011.
Section 6.
No, section 4. Section 4.2, the proviso to section 4.2 categorically mandates that the government is not responsible for the other excess teachers.
No, I am not the access teacher. madam.
Understood. So, but you have to be provincialized. Your service has to be provincialized.
No, my lord, this order.
Therefore, is it this order they would not hold it because there is a requirement of a provincialization notification under 10.4. 10.4, the school has to be provincialized, and while provincializing out there, there is a requirement of putting the names of the services who are being brought in, whether your name appears or not.
Look, that provincialization order is not a part of the record. my lord.
You should bring it.
I'll bring it.
Otherwise, your case is on a very weak.
My lord, I'll bring the same on record.
Mr. A.R. Bhuya, the learned counsel appearing on behalf of the petitioner, submits that he would like to file an additional affidavit on record to bring on record the order of provincialization of the school wherein the madrasa or school. Now it will be school.
Now it's a school.
Would be the of the school wherein which have been provincialized in terms with the Assam Elementary Education. What is that name?
No, the Assam Bhansar Madrasa Educational Institution, Provincialization of Services Act 2011.
After 4 weeks.
Nineteen and 20.
Lordship, here in this matter, the enquiry report is still awaited, Lordship. I seek for some accommodation, Lordship.
What entirely? Mr. A.R. Tabildar, the learner submits that the petitioner's PhD degrees are under verification and the verification is yet to be received, for which the affidavit could not. He therefore submits that accommodation be given of 1 month so that the affidavit could be filed. In the meantime, the heir shall file that. Then that was on 32.
Yes, Lordship, but we have not received.
We are in 36. 4 months.
Sometime, Lordship.
How much?
2 weeks, Lordship.
What?
That may not be, Lordship. On
No,
the
it
next
is
day,
required.
Lordship,
We have given you 4 months.
Lordship has one last chance, Lordship.
4 months. No? Petitioner is suffering.
Yes, my Lordship. Interim is there, Lordship. Interim protection is there, Lordship.
What protection is there?
Interim, Lordship. On 21, Lordship. 21/9/2000.
In provided that the service order should not be discontinued until further order.
My lord, the regular salary has not been paid, my lord. It is the fixed pay is given, my lord, due to non-consideration of PhD, my lord.
Due to?
Non-consideration of PhD.
Which PhD? From where did you get it?
It is, my lord, Singhania University, Rajasthan. Singhania University,
Singhania University.
my lord.
See? And why does it take such a long time for you to verify?
Lordship, that I.
Or is it the bad cases are being given to you to appear before this court? Whereas Mr. K. Gogoi appears in the good cases where all instructions are available. Huh?
My lord, already
It seems something like that.
5 numbers of council already stands, my lord.
No. When Mr. K. Gogoi appears, he has all instruction. Whenever Mr. D. Upamanu appears for this or health department, everywhere, he has no instruction. Why?
Lordship, today in those cases, I had the instruction, Lordship.
That is luckily because you were there.
Lordship, on the initial date of Thursday. Lordship, 2 weeks time, Lordship, as final chance, Lordship, last chance.
For filing affidavit. Heard Mr. K.U. Ahmed, the learned counsel appearing on behalf of the petitioner. Mr. D. Upamanyu appears on behalf of the Higher Education Department, who seeks some more accommodation as the verification process report have not yet been received by the Higher Education Department. This court duly takes note of that on 3/2/2023, 1 month time was granted at the request of the Learned Council for the Higher Education Department. By now, the 4 months have passed by from the last order. Till now, no such instructions is available. Taking into account the above, this court fixes this matter on 28/6/2023, on which date the affidavit be filed on or before 23rd of June 2023. Failing to do so, this court puts notice upon the respondent authority that exemplary costs could be imposed as delay in filing the affidavit have caused delay in the disposal of the petition.
Highly offensive.
23.
20 same, my lord. Obliged.
Same.
20, my lord, sir. 19 and 20 is same.
Same.
Obliged.
23, anybody? NH Paul Bhuya.
23.
Halilu Road.
Yes.
My lord, petitioner herein is was appointed lordship as a drop teacher. Lordship. The fact of the case is that lordship, when the petitioner was appointed in the concerned school lordship, the school was at Banta stage lordship. Subsequently, the school was provincialized lordship, but the petitioner service was not provincialized. And thereafter, Jivan Chandra Dekha's case came lordship, and then lordship ultimately in the year 2013 as a drop teacher he was appointed lordship. So, lordship, at the time of appointment of the petitioner lordship in the erstwhile Ventures school lordship, the petitioner was qualified to be a graduate teacher because madrasa final examination pass petitioner was lordship, and as per notifications lordship, it is equivalent to graduate lordship. And in this regard, lordship, petitioner submitted the representation lordship for enhancement of his grade pay to the senior classical teacher lordship. And that was already considered by the director lordship and submitted a proposal to the government for approval lordship. Page 25 lordship is the proposal. Last para lordship, third para lordship. May I read it lordship?
Lastly, the inspector.
Lastly, the inspector forwarded an application along with its enclosure submitted by Khalilur Rahman, Dewan, Arabic teacher, so-and-so school, Bongaigaon, through the principal of the school, requesting to enhance his grade pay from 2,500 to 3,300, along with supporting documents. The qualification of the teacher is FM, which is equivalent to BA as per notification of the State Madrasa Education Board, so-and-so, copy enclosed. The incumbent was appointed.
This was done in 2013.
This was done, yes, lordship.
Then why?
Thereafter, lordship, I have communicated lordship so many times with the department lordship.
You are given great pay of junior classical.
Junior classical. That was actually not junior classical. That was neither. That was lordship mistakenly given, lordship, perhaps. So that 2,500.
Understood, but this is why you are. We are at the stage in 2022. You have filed the petition.
Thereafter, in the year 2014, again director wrote a letter, lordship.
That I read it now.
Yes, lordship. So,
in 2017, after 3 years, you have done and that to given it to the minister. This court can't issue a minister read.
Yes, lordship. So
possible.
No, lordship.
Then the representation is useless. Did you give it to the minister while he was campaigning?
Lordship, perhaps that was a lordship faith of the general people, lordship. That minister will do everything.
Minister will do it.
So at this stage, lordship, may I pray, lordship, that as lordship, the government has not taken any decision, lordship, yet.
Yes, why government? Will he be entitled to?
That, my lord, I have to open this because this is based on a notification dated 22/11/1985. On the last page, the qualification of teachers is FM, which is equivalent to BA as per notification of the state government, state madrasa board issued number so and so, so and so, so and so. But in another case, I have gone through this notification, my lord. There is some confusion regarding this notification. So, my lord, give me 1 week time, my lord, I will obtain instruction.
Chalo, we write something out here so that you get something. If I just put it 3 weeks, then nothing is going to happen. At least give some credit to Mr. N.H. Bolbhuya. Yeah? That he has said something. Heard Mr. N.H. Bolbhuya, the learned counsel for the petitioner, Mr. N.J. Katunia appears on behalf of the
Secondary
Education Department. The case of the petitioner herein is that the petitioner in view of his qualifications is entitled to the grade pay at the rate of 3,300, which is given to the senior classical teachers. This aspect of the matter was also forwarded by the director of Madrasa or senior
secondary education.
Director of Secondary Education in the year 2013 and 14, but till date, the government have not taken any decision. The petitioner further drawing the attention of the communication, the order dated, which one? Which order you are saying that it's confusing? This one?
19th October 2013, that was.
That is not here. Which communication is confusing you?
There is a notification of Madrasa board, my lord.
Where?
22/11/1985.
No, is it enclosed?
No, my lord,
It is enclosed, lordship.
Huh?
At page 15, lordship.
It further appears from the repetition, more particularly Annexure 3, that there is a notification issued by the Deputy Director of Madrasa Education, wherein there dated 22/11/1985, wherein the examinations, certain examinations conducted by the State Madrasa Board Assam were held equivalent to the respective examinations. You have Madrasa Final FM.
Yes, lordship, FM.
As the case, but Mr. N.J. Katunia, the learned counsel appearing on behalf of the Secondary Education Department, that as the claim of the petitioner is based upon Madrasa Final FM examination to be equivalent to BA examination, on the basis of which the petitioner is claiming the graduate scale of pay. He therefore submits that he needs to take instructions in the matter, taking into account the same. List the matter again on 26th of June, on which date the learned counsel shall obtain the instructions.
High level.
आज एक मेंस फ्लोर है, मेंस फ्लोर है. What are you normal to make Oh, hey.